Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Thursday the 10th, and we are undertaking cumulative impacts and enhanced systems and practices rulemaking, and we will start with a roll call.
Thank you, Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
All right. Welcome. Good to be with everyone again. Again, this is the Energy and Carbon Management Commission, and we are continuing in docket 240600145, the cumulative impacts and enhanced systems and practices rulemaking. I believe that to sort of reset the stage, the commissioners were working through the document from the beginning to the end, hitting at high levels areas that deserve attention to provide additional edits and comments to staff. We hope to get through that document and then close things down and then let staff work on both the document and the statement of basis and purpose, which is the document that clarifies the intentions of the rules, get that back to us to have a final hearing on all of this on next Tuesday. So that's where I think we are. I think that we're at 302B2D. But before we go there, I spent some time thinking about one of the things we talked about and wanted to revisit something. And I am the last one that wants to revisit things, but I think it would be helpful. And this gets back to the area of evaluation and the director's initial determination as well as our review. My thoughts on this, now that I've had some time for them to congeal, are I don't agree that the clearly erroneous standard, which is the standard by which the commission would overturn a director's review at the end of a 6-month or whatever period of window of evaluating it, made a lot of sense. That standard would have the commission make a determination that what the director determined was clearly erroneous. And I can't fathom a situation in which I would ever believe that the director, and by extension, our staff, who are indeed the subject matter experts, did something that was clearly erroneous. So I don't believe that standard makes a lot of sense. We had pivoted to just sort of a review of substantial evidence in the record, which I'm comfortable with that, but it doesn't provide any bit of deference to the subject matter experts, which is the director and our staff. And so I think there should be kind of a combination of the two, move away from clearly erroneous, move toward substantial evidence in the record. Like, we're reviewing the area of evaluation after it's all said and done at the end of the period of the review. And if we find that an area or areas of review are not as broad as they should have been, we should send it back. But we should also have a bit of a deferential standard to the director and our subject matter experts before we do that. So I would propose that we rethink this along the following lines. For any proposed oil and gas location pursuant to Rule 304B2, the commission will defer to the director's evaluation of the appropriateness of the area of evaluation and may only require the operator to use a different area of evaluation if, and here's my new language, after reviewing the record as a whole, the commission determines that it is necessary to adjust one or more areas of evaluation to assess the extent of potential impacts. I'll read that again. After reviewing the record as a whole, the commission determines that it is necessary to adjust one or more areas of evaluation to assess the extent of potential impacts. This does a few things. One, it does provide a bit of deference to the directors and the rest of our staff's subject matter expertise that allows them to move forward based upon the director's determination of the area of evaluation. And then it allows the commission, after reviewing the record as a whole, that's everything, which is beyond what the director had when she made the initial direction, to determine that one or more areas of evaluation may need to be adjusted. And I like that piece too, because we've been thinking about this as a whole, that all of the area of evaluation is wrong. And I don't think that's necessarily going to play out as we play one of these things out. I think it may be that we think, okay, with regard to air, got it right. With regard to nuisance, got it right. With regard to water, wait a minute, there's a lake here. There's 18 streams that are flowing into it. We really ought to take into account that lake because of the circumstances of the particular application, even if it is beyond the 2.5 mile down the stream sort of thing. So that's what I would like to initiate this morning. Sorry to jump right into the substance of it, but that's what I've got. Commissioners, Commissioner Messner?
I appreciate your language. I mean, I don't have a problem with the language that you suggested here. I also thought about it a little bit, and I continue to think that maybe we're thinking a little too hard about this because, like you said, I think in a lot of elements of an application, we provide deference to the director and the staff and their evaluation and the work that they do and their determinations of certain things. And as we look at them as a whole, like we do on the, as we are looking at applications, we ask questions and maybe ask for additional information on certain things in order for us to be able to fully understand the application and make a determination. I think I agree with you. I really don't see situations where we would, utilize, any other area of evaluation besides what was determined by staff and the consulting agencies. And so, if it's important to have this word deference in there, then I don't have a problem with that. I know that the word deference has some legal ties, but I think that in practice, that's what we do anyway. I do also want to emphasize, though, that this is why I think it's really important that we have appropriate default areas of evaluation so that we don't have to go down this road ever, right? Because if we've properly determined areas of evaluation for the different resources, in this rulemaking, and I'm not saying that we haven't, but if it does appear that we've got, if we're utilizing this adjustment of the areas of evaluation a lot, then maybe we don't have the right initial default areas of evaluation for particular resources. Because I really would hope that we're not making a lot of adjustments to the area of evaluation from the default. I mean, that's, to me, where we should be landing in this rulemaking, is an appropriate default area of evaluation. So we're not utilizing this adjustment tool very often, if at all. So those are my initial thoughts.
Yeah, no, I appreciate that, Commissioner Messner, and I agree. And kind of another thing that I wanted to lay out to the world at large in terms of the rulemaking we're undertaking. Please, everyone, understand we are undertaking an ambitious and never before done rulemaking around cumulative impacts, and we are doing the very best we can to make sure that we're landing in the right spots on a lot of very novel and new concepts. And what I'm getting at is that I anticipate this is not a static rulemaking, and I anticipate that we're going to be coming back and making adjustments and continuing to refine the Colorado regulatory approach on cumulative impacts and enhanced systems and practices and disproportionately impacted communities, as well as the rest of mission change, as we've continually done over the course of the last 6 years that I've been around. And I just want to sort of lay that framework to everyone to understand that that's, where we're at. So appreciate those points. Commissioner Oath, I know you wanted to weigh in.
Oh, thanks, Mr. Chair. I too think that language makes sense. Particularly, I liked that you called out the fact that if there is some adjustment to an area of evaluation, it may not be overall, but maybe to a specific resource element where it may make sense to adjust. So I think that makes a lot of sense. And agree also with Commissioner Messner's comment that, we shouldn't anticipate that we would be doing adjustments frequently. And if we are, then that might mean that we need to take another look at the default in general, which I think to me is kind of further underscores some conversation that we had in our deliberations a couple of weeks ago about wanting to have some statement of basis and purpose language, laying out that we want to get an update on these and revisit this, at a prescribed period of time to make sure that we're checking in and saying, well, how often have we adjusted, and does that mean that we should be making some tweaks to kind of the underlying regulatory default areas? So I think that makes a lot of sense, and just wanted to share those thoughts.
Yeah, I appreciate that. Commissioners Cross or Ackerman? Mr. Commissioner Ackerman?
Yeah, I also support this, and I appreciate you giving it thought, Mr. Chair, for the reasons that were just pointed out. I particularly also appreciate that you had in mind that that things do change over the life of a project, and that when we have the entirety of the record before us, there might be some things that arise that we can take a look at, if necessary, that may not have been available to the director. So I think, to me, this is highly preferable to the clearly erroneous standard, and appreciate it.
Commissioner Cross?
Thank you, Mr. Chair. And I was trying to write down as quickly as I could, but could you go through the language one more time so I make sure that I have it? And I had the determines a need, and I think I lost a couple words in there.
Yeah, give me just a sec. I've got to get back to the. It is after reviewing the record as a whole. In fact, let me do this. AAG Davenport, do you have a chance to screen share the language?
I do.
That might be easier. And then all of our we only have 39 stakeholders this morning. But I wanted them to be able to see the language as well. Well, normally in like the 60s and 70s. I don't know what we've done. There you go. Commissioner Cross, can you see that?
Yes. Oh, now I lost it.
Sorry. Okay. It should be back now.
Yep.
So this wouldn't be tied to a specific legal standard. It would more so just be upon our own determination.
Yeah, it's kind of like my move from between good faith and best to all reasonable.
Okay.
With the SBP providing some clarification of what that means, and I would want to see the same thing here. I think we've got the integrity to be able to sort of review these things. I agree with Commissioner Oath and Messner that I'm not thinking this is going to be a, often occurred thing, but it does provide us with one, deference, two, the record as a whole, and three, the concept that we may not be needing, if we find something that needs to be adjusted, it may just be one area as opposed to the entire area of evaluation, which is where kind of the clearly erroneous place had been previously, was like we're adjusting the whole thing.
Okay.
Mr. Chair, sorry to interrupt.
No, I was just going to say I understand that, and I don't know that the clearly erroneous standard is necessary either. I agree. I think this will probably be used in extremely rare circumstances. My only hesitation with it is I think it sometimes provides a level of uncertainty in the regulatory process as to whether something like this might come forward. But again, I understand that this is also something that's probably going to be very rarely used. And so I do think that makes sense. And I think some explanation in the statement of basis and purpose can help with that.
Yeah. And so I would suggest to AAG Stafford to capture, I think, the unanimity of the commission that this is the new language, and that in the SBP, there was discussion amongst commission that this would be likely utilized in a rare instances. I don't know if we want to go so far as to say in that if it happens to be that we're reevaluating areas of evaluation as a commonality, we would probably want to reevaluate the default areas of evaluation.
And I'm sorry, I'm in for a moment, please.
Go ahead.
Thank you. In response or in regard to Commissioner Cross's comment about the standard, in my view, the word necessary is what does supply the standard here. In other words, and necessary is something that the commission I think is familiar with. And in my view, necessary would essentially provide that the commission needs to find that the area valuation needs to be adjusted because otherwise it would not be able to assess the extent of potential impacts. And that's where the necessary comes in. So I don't want to suggest, or I don't want to leave open that there's no standard here. I do think the standard is the word necessary.
No, I appreciate that. Commissioner Cross?
And I appreciate that as well. And I'm kind of wondering, based off of some of the language that we use elsewhere throughout the rules, if it makes sense for it to be necessary and reasonable to adjust one or more of the areas of evaluation.
I'd be comfortable with that. That sort of syncs it up with the rest of the rules that we have, and I don't think that's a value de-add. It probably is a value add. Other commissioners with thoughts about that? And I can't see all of you because Kyle's sharing a screen.
I think I just might have missed what Commissioner Cross suggested. Do you mind repeating that, Commissioner Cross?
Certainly, Ed. So what we have with respect to a lot of the protections that are added in now is if it's reasonable and necessary, or necessary and reasonable. And so just adding that and reasonable as well for conformity purposes.
Commissioner Oath, did you catch that?
Yeah, thank you.
Commissioner Mesner, did you want to weigh in?
I don't have any problem with the word reasonable. It's in there. It's what we have to do for every rule. And so it can be used wherever it needs to be used in the rule, just like the mitigation hierarchy. So I'm going to throw this out there, and I'm not, again, because I don't want us to use this very often. I'm asking for commissioners just to think about this a little bit. I don't have to make a decision right now, but when we look at the areas of evaluation from a default standpoint, and so we're not utilizing this, my only concern is that we've got CDPHE that made a recommendation on water, and so we expanded an area of evaluation for CDPHE so that they're not having to continue to make recommendations to adjust the area of evaluation. I'm not sure we gave that same deference to CPW in their recommendations as far as the mile area of evaluation around proposed oil and gas operations. And so I guess my only concern would be that if CPW in their consultation, either in the pre-application meeting or further on, suggests something different than the area of default because they've expressed to us that it's important for them to be able to evaluate a mile around areas proposed operations, oil and gas operations, that we wouldn't be setting ourselves up for these adjustments to the default, which I think we're indicating here we don't want to. And so that would be the only other like resource specific one where we had an agency make a suggestion on an area of evaluation that we didn't adopt. And so just something to think about there.
Commissioner Messner, I appreciate, I'm not sure I'm totally following. Are you suggesting language edits or are you just suggesting clarification on the record here?
I'm suggesting that we take CPW's recommendation for the area of evaluation. So again, now we're going backwards, and I don't mean to go backwards.
It's okay.
But to adopt their recommendation for the area of evaluation, which is my understanding of it at least, was that it was a mile around areas of operation. So that would be proposed operations in the application, right? So that could include some access roads and some offsite facilities that are directly tied to those operations on the working pad surface itself. I think I heard them make that recommendation as a default area of evaluation, and so that's the only suggestion I would make is maybe we rethink about that particular area of evaluation so that we're not getting into these adjustments very often. So just something to think about.
Okay, well, I appreciate that, and let's pen that. Let's add reasonable and necessary to this language, and I think we're comfortable with at least the area of evaluation reconsideration language by all five of us. So, AG Davenport, at some point, if you could add in and necessary, then we'll be at a good place here. I think we've gotten direction on the other front, and then we need to reconsider the CPW issue at the appropriate time from Commissioner Messner.
Yes, Chair. AG Stafford is kind of the keeper of the formal official document here, so I would ask that she add "and necessary" there.
Okay. Then if you want to stop the screen share, I'll be
Yep.
able to see everybody again.
Should have stopped it by now.
Okay, great. And I'm still here. Okay. All right. Moving in the forward direction, and apologies for taking this backward. I believe we're at D, measures to avoid, minimize, or mitigate adverse cumulative impact. AG Stafford, does that coordinate with your understanding of where we had left off?
Yep, it does, Chair. I will screen share momentarily. Excuse me.
Hey, dude.
Is the text large enough for everyone?
Yeah, if I'd lean forward and squint, it's perfect.
Okay, so no. Hold on.
That's better. That's great. Thanks. Old eyes here. Okay. Once again, I'm in a place where I only see like 2 of the 5 commissioners. So does anyone want to raise up with any thoughts, concerns about the language in this section D?
So I did bring up a suggestion at the end of last meeting, and I believe, if I recollect correctly, that there was, I think you had recommended that AAG Stafford think about it a little bit, but my suggestion was, while I acknowledge AAG Stafford's concerns about being more specific about inclusion of avoid, minimize, and mitigate from a desegregated standpoint throughout the rule series that we're considering here because of its potential implications to other rule series that were not noticed. And so I acknowledge and understand that. My argument on this one is that I think that if there is a section in the rules that could use, then these are rules that have been noticed that could use, I think, more clarity from how the mitigation hierarchy is to be implemented, associated with evaluating and addressing cumulative impacts, which is what we're doing here today, is in this section, which is titled Measures to Avoid, Minimize, or Mitigate Adverse Cumulative Impacts. And so I had suggested that the allied local governments had provided some suggested language on ways to desegregate and evaluate, avoid, then minimize, then mitigate as part of this 315D section here. And, you know, I liked the basis of their concept there, and it was really in 2 or 3 different parts in their red lines that they provided. And I think that's where we left it at the end of last meeting. And so I'm just trying to set the stage again for this morning's discussion.
Appreciate that, Commissioner Messner, and I will me too those thoughts. You know, I have suggested in the 604 arena where I was working that I would put it into the SBP and not like reiterate it on each criteria, I think that still makes sense. But I also think that because in 315, we really are calling out the avoid, minimize, and mitigate. And I appreciated the way the allied local governments had extended that. And I think it could be a good place for us to place within our rules, particularly in this 315, that hierarchy and call it out as to how we're dealing with cumulative impacts. I think it would be a good stepping stone for us and potentially help us down the road as we potentially think about this in other arenas. And so I don't know exactly how to like instruct AAG Stafford to move what the language is here into language that's more consistent with the allied local governments, but I would be in support of that movement and approach as well. Commissioners Cross, Oath, or Ackerman, thoughts? Commissioner Oath?
Maybe more of a question. Do I remember correctly, Commissioner Messner, did you note on Tuesday that you had some red lines that were largely drawn from allied local government's proposal on this issue?
So I do have red lines in my draft. They are drawn from allied local governments. I do think that there's some tweaking in the language that I would do with the allied local governments suggestions, and keeping the intent I think is there. I think the concepts are there, and I like what they provided there, but I haven't like added my flavor to it. So I think at one point we talked about Commissioner Ackerman working with AAG Stafford and Ms. Trask on looking at some language, and before Tuesday. I'm also happy if the commission would like to think harder about this and provide at least my thoughts on the red lines and propose those to AAG Stafford and Ms. Trask before Tuesday, if that is easier for us to get through the process today, or I'm happy to wordsmith it with my fellow commissioners today as well. But I guess the root of that is that the language that allied local governments provided, I think, is good, and so that may not be necessary to have me do anything different.
Yeah, I would be. I'm happy to go either way, but I would be comfortable. I think that the allied local governments language was vetted through the process. In fact, I even think that one of the stakeholder companies, Occidental, had provided some positive thumbs up to the allied local governments language. And I sort of like the concept of using language that's been stakeholdered, by all parties. And so I'd probably want to start there and just sort of get a sense of, what the commission thinks about that. But I'm just one commissioner and I don't want to upset your apple cart, Commissioner Messner. If you've got other edits that you think fine tune it and make it better.
You're not upsetting my apple cart. I don't really think that there's very much. And so I'm fine with that approach.
Commissioner Oath?
Yeah, I also agree. I mean, I appreciate the staff's and AG's thoughts on this. I think when we talked a few weeks ago, we had talked kind of the same thing about drawing from their proposal on this concept, and appreciate that staff came back noting that they felt like it was more appropriate in the statement of basis and purpose, and so don't want to discount that, but do think that for this particular section, it makes sense, and so support that would be the language that we would be looking to as a starting place. So I'm in agreement.
AAG Stafford, are you comfortable with the direction to try to work in the ALG concept language at this point for us to review on Tuesday?
I'm comfortable with that direction. Thanks.
All right, then if we want to, I guess maybe move to the next section. All right, resource impact descriptions. Thoughts, anyone?
So I'm trying to catch up here. I do have one suggestion, and again, this came from the allied local governments, but they had made a suggestion for an evaluation of the cumulative impacts associated with transportation corridors. And I acknowledge that there's this push and pull between transportation from a local government standpoint, transportation from a state standpoint, transportation corridors from a federal standpoint. Understanding that, in our process, we can only control what we have the authority to control, and that's been clearly laid out in statute, and I think we've followed that through this whole process. But understanding that this is an evaluation of potential incremental impacts to incremental cumulative impacts associated with traffic or transportation impacts, it seems appropriate in this section to include that concept in an area of evaluation or evaluation of cumulative impacts. And so I would recommend that we think about that.
Ms. Stafford, can you highlight the language that's being pointed to?
Chair, the language is not currently in this draft. I know staff was previously uncomfortable with including that particular language, but I would have to confirm with Miss Trask her reservations there. She's currently not available.
All right. Well, I'm not sure I have an opinion at this point, but we're going to create a parking lot for Miss Trask, who's going to be available at 2 p.m. today. So why don't we park this car in that parking lot and continue forward? Is that okay, Commissioner Messner? Yeah. Okay.
Chair Robin.
Oh, yeah, go ahead. Again, folks, I can't see everybody, so you're just going to have to pipe up, and it's against normal protocol that works.
And so I guess I would, as recognizing it's appropriate to maybe put this in the parking lot area, I guess I have one question for Commissioner Messner. Would this be a separate section, or would it go under air quality, under noise? Where would you see this going if you had something in there?
It's being proposed right now as a separate section. So cumulative impacts associated with transportation corridors. And so, I understand the challenges here, but I think as we look at cumulative impacts associated with, public welfare, the environment, there's a lot of elements that kind of incorporate traffic or transportation corridors, so to speak. And so as you're looking at cumulative impacts and the potential incremental increase of adverse cumulative impacts, I don't think we can not consider truck traffic, associated construction traffic on highways, county roads, byways, neighborhood streets, those elements. There are other parts in the kind of resource evaluations that kind of pull a little bit of it together in different places, but I think the suggestion here would be to kind of have that as a separate resource for evaluation.
Okay, thanks for that clarification.
All right, anything else under subsection E? Noting that if not, we've done a good job of redlining this and getting it to a good space.
So not in section E particularly, but one other concept to throw out there because again, we're evaluating cumulative impacts. And in this section, we're really looking at it from a resource perspective, you know, throughout all these different sections, whether it's air resources, water quality resources, you know, surface impacts, wildlife. I mean, we're going through the whole resource place, but we don't really have a section where we're synthesizing it all. And I think that was something that Ms. Burke from Boulder County, Ms. Sanchez from Burleigh County really emphasized. Like, if we're really going to look at cumulative impacts, at some point we have to look at them holistically between all the different impacts and synthesize them in some way. And so there was some suggested language in there for us to evaluate the synthesized cumulative impacts associated with the application holistically, or to have applicants evaluate it from a synthesized perspective. And I mean, it's a relatively new concept, and so it is, but synthesizing impacts is not a new concept, but understanding that, you know, taking all of these parts and pieces together and looking at it holistically, you know, is a little novel, but I think it makes some sense, and, you know, would encourage us to consider a section in there that would be a synthesizing section. And so I'm curious about other commissioners' thoughts.
Did and I'm sorry if I didn't catch it, but did anyone provide language for this concept?
Yeah, ALJ did, or ALG.
Could we find that language and put it up on the screen?
I can't put it on the screen, but I can read it to you.
It looks like Ms. Stafford's working on it.
And if
So
I may
Nick-
briefly, that transportation corridor language is right above it if you want to return to that point after this.
Okay, that sounds great. So synthesis of resource impact descriptions, narrative analysis of the combined impacts set forth in all evaluations performed under 315B2E that will not be fully avoided, minimized, or mitigated, and how they will combine with existing conditions and how they will in the impact area and how they will combine with each other to create an overall impact profile. What's the AG Stafford, if you could help me, how they will combine with existing conditions is one point, and then the second one, how they will combine with each other. How does that play out in practice? That's kind of two different concepts.
Thanks, Chair Robbins. I think staff was similarly unclear how this would work. There's also some language in here that I'm not sure fully comports with how we would be applying the mitigation hierarchy. So similarly, I am not quite sure how this would work in practice. So I don't have any additional thoughts there.
I wonder, excuse me, I wonder what if I like the concept. I think it's a value add once again. I guess because I'm uncertain about the two, how they will combine pieces, what if we just ended the sentence after the word mitigated and just had the narrative analysis of the combined impacts that will not be fully avoided, minimized, or mitigated, period? Because I guess I can't read meaning into the other two pieces. And now we're doing the things that I don't like, which is navigating on the fly with language, but so be it. Other commissioners would like to ponder into this idea?
So I don't have a problem with that. I mean, again, I think, this section is really designed to evaluate, so it's an evaluation of cumulative impacts of the different kind of resources, and then it's the synthesis of that evaluation. And some of the pieces in the bottom, may go more towards the review of the cumulative impacts analysis. And so I acknowledge and understand that as we were reviewing the cumulative impacts analysis, we need to look at it as a whole anyway and determine, how it avoids, minimizes, and mitigates. I think this synthesis piece helps provide some information to us on how the different parts and pieces work together to create an overall impact profile. And so I do like that term, overall impact profile. But I'm not sure. I do agree that it's kind of a 2-section piece at the bottom. And so I think that there's some language that could be developed talking about an overall impact profile, or how all of these things, create this picture, because really we're trying to paint a picture here, right? So I mean, we've got these different sections and different resources that we're evaluating, and ultimately we're trying to paint a picture so that we're, when we're making a determination of evaluating and addressing cumulative impacts holistically, we have that picture, and then we look at how the operation has avoided, minimized, and mitigated the cumulative impacts of the proposed operation. And so I think you're right. I think you could end it at mitigated, but I would like to include, how it also creates an overall impact profile, or, helps us paint that picture.
Well, I would suggest we stop at mitigated, and then if the AAGs feel that they could use some of the language that we've cut out in the SBP to further refine this point, I could be comfortable with that or not. Commissioner Cross?
Thank you, Mr. Chair. And I'll just say I agree with the stopping after mitigated. I think that this is a valuable way to look at kind of a holistic kind of conclusion of what's been talked about. So in the rest of 315B2E, we're saying, like, here's the impacts on climate, here's the impacts on water, here's the impacts on wildlife, biological and soil resources, et cetera. And so we have that kind of description, recognizing that those are different resources being impacted, and how they're impacted. And then here we can say, listen, for what's not being avoided, minimized, mitigated, here's kind of what's still out there. And so I think that then puts it back kind of in our lap as to how we look at that, as opposed to trying to rely on the operator and what their views on what the impact profile is. I think that's better left for us as a commission to say, we're now seeing what's not being mitigated and avoided and minimized, and we're instead looking at kind of the totality on our own and determining the appropriateness.
Commissioner Oath?
Thanks, Mr. Chair. As I've been kind of mulling this over, I'm initially my understanding or thinking about this ad was along the lines of like an executive summary of kind of the cumulative impact analysis as a whole. And I'm still not totally sure if that's right, because in one way I could see this being kind of an overall summary of some very lengthy, dense, technical kind of analysis under each of the resource areas, which could be helpful. I know we did add a requirement for a plain language summary, which I think, was mostly intended to be geared towards community, but could be in some ways similar in that sense. So then when I think about this, though, using the word and thinking about it as an analysis, that's different than a summary, right? More of like this impact profile idea and concept. So I'm a little bit torn on this, what Commissioner Cross was just noting about who's the right where is that is appropriately done, right? Whether that is the operator providing that kind of an analysis or their perspective on that analysis, or if indeed that is kind of the work of both the staff as well as the commission in terms of reviewing it as a whole, including the summary and kind of doing an analysis. So that's not a position. Those are just thoughts as I think about this.
Sorry, I'm muted. Other thoughts from commissioners on this?
I think Commissioner Oath brings up a really good point there, you know, and I'm reading it again. And it is, and so, you know, it is an analysis, you know, because I think where Chair Robbins has suggested we end it at mitigated, it is asking for an analysis of the overall painting that was painted with all the different evaluative resource specific plans. You know, I think that this is ultimately what we're asking operators to do, is look at it holistically. I think we're asking staff to look at it holistically. I think we're asking ourselves as commissioners to look at it holistically. And so I think the synthesis piece is helpful to give an operator a chance to share it. I also think it makes sense to, you know, have this as kind of a evaluative criteria, you know, in a director's recommendation. I also think it's really good for us as if we're going to walk through and look at whether or not an operator has evaluated and addressed cumulative impacts as a tool for us to walk through as well in our evaluation. And so, you know, again, I bring this up as a discussion point amongst commissioners, right? And so I'm not saying that I'm strongly advocating for it, or I really wanted to hear other commissioners' thoughts, but I do like the idea conceptually of this kind of this synthesis concept, and, you know, allowing an operator to make their argument essentially on how they feel like everything's tied together and what the overall profile is, for us to do that and for staff to do that in their evaluation. So I guess those are my thoughts.
So have we landed it that we'll stop the sentence at mitigated, and if the AAG feels there's some additional ability to clarify an SBP with the remaining language, she's got authority to do that, and then we'll see what comes back?
Because I was not as clear when I spoke earlier, but thinking about this more, I would be supportive of adding this. I agree that having an operator's perspective on the synthesis will be helpful, but we will want to be doing our own analysis and synthesis of kind of the overall cumulative impact analysis ourselves. So yes, I would agree with what you just noted.
And the point you just made, Commissioner Oath, could also find its way into the SBP. AAG Stafford, Commissioner Oath is nodding in an up and down fashion, so you were so instructed.
Could I just get one clarification? Will I have some ability to adjust some of this language? I'm concerned with some of the wording here, particularly as it relates to the words fully. I don't know that anything can be fully mitigated. So if this is the direction that you all are intending to go, I'd like to have the ability to work through this actual language, because I don't think it is currently workable as is.
I'm very comfortable with you bringing your legal mind to this and drafting it in a fashion that is going to be workable for everyone, including the operator that's doing the narrative analysis and us that are going to be fully, or going to be understanding what that is and making determinations upon it. I'm not seeing anybody objecting to that, so you've got leeway to do that. Do we want to go back to that transportation piece real quick, since it was already just kind of right there? Okay, Commissioner.
We're gonna wait for Ms. Trask for that conversation.
Oh, yeah, thanks. Sorry, I keep forgetting Miss Trask is not with us. So we'll put that back into the parking lot. All right. All right, we're at 316. I, uh, Commissioners, with your pleasure, I'd love to go fill my coffee cup up. So before we dive into this, can we take maybe 3 minutes and return at 9:54? And everybody take your break real quick, and then we'll come right back. All right, we are back. Apologies for the 2-minute extra delay. Someone forgot to make me coffee. So, but I'm well equipped now. We're going to move into, I think, 316 now. AG Stafford, is that right?
Before we go into 316, I've got one minor to finish it out.
Okay.
So this is under the review of the cumulative impacts, and this is another great place to clarify this desegregation of the mitigation hierarchy. And this is one that that under C, Romanet 1, the first line could say efforts taken by the operator to first avoid adverse cumulative impacts. Create a new Romanet 2 that says efforts taken by the operator to minimize adverse cumulative impacts that could not be avoided. And then everything else would stay the same. And then that breaks down that 3-step process in our review. And I think that could be really helpful from a clarification standpoint. And it seems pretty simple.
So add in first, sorry, the language is moving around on the piece there. Efforts by the operator to
first avoid adverse cumulative impacts.
To delete out or minimize in that section, and then add in a minimize in Romanet 2, and then Romanet 2 becomes Romanet 3.
That's correct. So Romanet 2 would be efforts taken by the operator to minimize adverse cumulative impacts that could not be avoided. I mean, this is taking language from the existing SBP and just making it part of our review, which I think is really helpful for commissioners as they look through the review. And then the rest stays the same.
I will just weigh in and say I think that makes sense. So I'm good with that.
Anybody have concerns? All right, then I think we're moving onward.
Chair, if I may, just to circle back to the synthesis one more time to make sure I'm clear on what I'm doing. I will be incorporating a new subsection that is modeled on sort of the first half of the ALG suggestion, and then the SBP will discuss the expectation, what we want to see there. Is that correct?
Yeah, to your drafting desire. I think it's the first part is something that we've agreed upon. The second part is for you to consider. And if you think it's adding some value, you can add language in the SBP, but I don't think it's mandatory. We're leaving it to your drafting pleasure a little bit from a lawyer perspective. That's at least my piece on that.
Thank you.
The one piece I would like to see in the statement of basis was kind of the conversation we had around while we want the operator to provide this analysis and then synthesis. It's one perspective on that, and that kind of the staff will be doing their own, as will we.
Are you feeling good with that direction, AG Stafford?
Thank you. I appreciate it.
AG Stafford, can I ask you a leading question here? We're at 316, and we've got language that is the language that we've been contemplating, and then we also have some language that I've put forth in terms of the work that I've done. What's the best way of going through this rule?
I think my recommendation would be to see if any commissioners have any edits for subparts A or B, and then I can bring in your proposal for C, and we can work through that. And then I would need some time to incorporate it into the draft if that's something that the commission agrees upon.
And I think we're going to have that time because we're going to break after we get through all this morning, and then come back at 2 to have a discussions with Ms. Trask. And so that could give you a little bit of time to do some formulating between the two. Does that sound accurate?
Yeah, I should have time to make those adjustments.
Okay. All right. So Commissioner Oath.
Yeah, I just have a couple of changes in 316B. And they are all the three things that we talked about on Tuesday, Ms. Stafford. So one of them is quite in the weeds, but I think important. So it's in B1B, that first little I, and it's combining A and B, because otherwise I just think the ands and ors are confusing. Anyone want me to further explain that, or is that okay?
I think that looks, I'm not hearing anybody else, so let's get that done.
The other two are changes of mays to wills. So under B3, a little I. So this would be the case where we're working through the submission of a Form 2D, and the little I is intended to be this concept of where an operator is overly compliant, then then we're not going to be taking a closer look at under their upcoming operations. We're sort of determining that if there's that much buffer between their compliance in the past, that we feel confident we don't need to take a very close look at their intended actions for the upcoming season, their Form 2D will be approved.
Commissioner Cross?
Thank you, Mr. Chair. And I think my one comment on this area was just going back to the point I raised about the 20%. And I know it was discussed during our kind of consensus discussion. I still think 15% should be considered instead of the 20%. I think 20% just is probably a lot and almost might make it kind of superfluous overall, if it's to such an extent that probably nobody's going to hit it anyway.
Yeah, Commissioner Cross, I appreciate that, and I too want this to be a viable thing. And I think everybody's got to evaluate the right number for themselves. Where I'm coming at this from is we don't know yet how much uncertainty or how much variability, excuse me, we're going to have year to year. And so this is not a, you're not going to be able to move forward or get approval. This is just a, what's the big enough buffer of compliance in the past that I personally would feel comfortable at this point with not knowing, not knowing how much or how little variability there is, that I'd be comfortable kind of just green lighting, like with the checkbox kind of thing. Totally appreciate that, others may feel comfortable at a different percentage. That's just kind of how I'm looking at it and how I got to 20% myself, but I think it's a valid thing to discuss.
I'm happy to share that I think the 20% seems appropriate in this because I think it is important to understand that it doesn't eliminate a path forward. It's just creating an incentive essentially. I think 20% is appropriate, and I think if the number needs to change, in a future rulemaking, I think that's certainly appropriate. I think we've acknowledged that that's something that may need to happen with a number of different rules that we're looking at. And I don't know, at least with even an application that we approved yesterday, it seems like they were well above the 20%. And so this would apply to. And so conceptually, because I know these aren't applicable yet, but so anyway, I'm comfortable with it.
All right, I feel like we've dealt with this. Commissioner Oath, did you have other?
Yeah, one more. So it is just a bit further down in two little I's, the BB. So here, for those that are not overly compliant, and we are taking that closer look, in BB, it's after the director takes that closer look, if they believe that the proposed pre-production operations demonstrates that the operator can comply with their NOx intensity target, I believe it should say that the director will approve the Form 2D.
Okay, so that's consistent with our previous discussion. Any concerns, folks?
Thank you, Mr. Chair. That's all I had in this section.
All right, any other thoughts here? Commissioner Messner?
Just a thought, because I appreciate the modifications here. I think they're appropriate. I wonder if those same considerations would be appropriate in the areas where an operator is not in compliance and would make it, and the director would need to make a determination of whether or not to approve or deny that application, because there's maze in there as well. And so I don't know, Commissioner Oath, if you had thoughts on that as well.
I
know
do,
they're further down, and so I'm not sure where they're.
I think that's in 316D, and so I'm reserving that part for the kind of conversation where that Mr. Chair Jennifer talks about his pieces. But I agree with you, Commissioner Messner. There is a piece of that as well.
Okay, thank you.
Anything else? AG Stafford, where should we go next then?
Thanks, Chair. If you can give me a minute or two, I can find the other document.
Okay, commissioners, we have up before us the work that I had done on 316C. First, and I can't remember, I think I've walked through this for you or before, maybe at the beginning of the meeting. And so now you've hopefully had a chance to sort of digest some of it. And so we're looking to see if we're comfortable with the places that, I had made suggestions. The first was the applicability section. The C2 and 3 remain effective on the effective date of January 1 of 2025. And 316C4, there had been a request from some stakeholders to have that applicable in January 1 of 2026. The previous language was similar to the current language on Romanet 1, which is for any Form 2A submitted on or after January 1 of 2026. I had concerns about that. I felt like that actually added many more potential years before 316C4 comes into effect because it was just based upon a Form 2A submittal date. And so I redrafted it for any and all construction to an oil and gas location after January 1 of 2026 for Form 2As approved after the effective date of these rules. I feel that that's a good middle ground to place. It gives the operators an opportunity to plan for the more harder to reach ESPs, but it also provides a firm date for when those are going to become effective. So that's the rationale behind the change that you see here at C1. Open it up for questions, dialogue.
Mr. Chair, I think I'm feeling a little dense here this morning, but so it says the requirements of this Rule 316C2-3 will apply to all new oil and gas locations for which Form 2 is submitted pursuant to Rule 304A1 on or after January 1, 2025. And so you're saying that the submitted is okay in Romanet 1, but you've changed it for the 2026 piece to be the new construction. Am I understanding that correctly? I just want to make sure I understand.
Yeah, the submitted in the Romanet 1 is the language that we had in place from the beginning. And the stakeholders that wanted the additional year had a similar submittal piece for Romanet 2. And I had concerns that that would elevate C4 not becoming into play until much beyond 1 year. Because if you submit something after January 1 of 2026, it's going to take, 4, 5, 6 months to potentially get approved. And then potentially another, year, 2 years before you start actually constructing. And so I wanted to allow for the additional year for the harder to deal with ESPs, but I didn't want it to roll into a multi-year application. That's the movement toward new construction.
Okay, no, I appreciate that. That's clear to me. So it's possible though that if I'm reading it correctly, that even something that's applied for that's submitted today, not today, today could require the requirements of Rule 316C4 would apply if they didn't do any activity on that until January 3rd, 2026. Is that the way you're reading it?
No, I think that the language on Form 2As approved after the effective date grandfathers pre-existing applications for the C4 stuff.
All right. Yep. Okay. So now I fully understand. Okay. Thank you.
Commissioner Cross, would appreciate your thoughts on this being the industry seat here.
No, I think this is appropriate. And frankly, I think the 316C2 and 3, that's referring to a lot of the Reg 7 drill rigs. That's something that they should already be working on doing. And 3 includes some of the, as was kind of described, the easier BMP/ESPs to get things done, the covering of the cuttings, et cetera, things like that. And I think that those are things that can and should be done quickly. And especially we're working with CDPHE. These are the BMPs, the ESPs, as we're calling them, that are going to have kind of the biggest bang for our buck. Frankly, I think with respect to 316C4, it's appropriate. I agree with the changes for the construction. I don't want to have this drawing out to things that, oh, we filed something on December 30th of 2025, and we're not going to construct for a couple years after that. And now we're looking at things being potentially 2028. I agree with this should be construction after January 1st, 2026, but I think this does provide an opportunity to make sure that these new ASPs can be implemented, and we don't start to see a lot of variance requests and things like that coming from it. And I think that will help overall. And I think that's also appropriate, not because it can't be done by that time, but I think we have to also remember that a lot of these that are currently trying to be or will be filed in the next couple months also have been in plans and for a year or more at this point in time. And so if they've been working on some of the pipelines and stuff and they don't have it set, but it's kind of ready to go and going to be filed in the next couple months after the effective date, then I think this provides the additional time to make sure that they can try and get those additional more difficult BMPs, ESPs in place in time, but without, again, pushing for the 2-year or more start time for this.
Appreciate those thoughts. Commissioner Oath Ackerman, any thoughts here?
Nothing really to add, Mr. Chair. I think this makes a lot of sense, and I'm in agreement.
Yeah, same.
Okay. Then if we want to continue through this, maybe highlighting the other changes that I had suggested. Okay, and commissioners, this suggestion, frankly, I'm not sure how sand management technology found its way into the list of things that address ozone, because in my non-scientific mind, sand management addresses dust and other issues rather as opposed to ozone, but it's in here. And then some stakeholders had some concern that right now it just has closed loop sandbox technology and that there are other sand management technology and procedures that are equivalent to that. And so this was a nod to that point, that we want best management practices around sand management technology and not necessarily calling out one in particular. Commissioner Cross?
Thank you, Mr. Chair. I agree with this ad. And I would also note, I think there's only one contractor that uses the closed loop technology. So it would also create a bit of a problem in terms of trying to get different contractors to do it. Would essentially kind of be creating a monopoly on that too. So I think it's also appropriate to make sure that it, as CDPHE also mentioned, it's appropriate to try and make sure that we do this in whatever way is necessary to minimize this, as opposed to using something prescriptive.
Anybody else with thoughts, questions, concerns here? Okay. So I think we should roll down to the addition of electric drill rig engines. So commissioners, in the work that was done on this issue, some stakeholders had not wanted this practicability out for anything. We had started with electrification as well as the non-use of tanks unless practicable. I still think those are something that we should incentivize, and we'll do that through this section C. I heard from other folks that if we're doing this, we ought to also include within the practicability assessment all drill rig engines. And so I made that insertion here. And then we've got the practicability assessment at the next stage where I made one additional element to that. So this is the place that I'm suggesting is a good place to land on these sorts of tools for us within the ozone non-attainment area. Commissioner Oath?
Thanks, Mr. Chair. I will just say I very much support this addition and where you landed on it. I think it's very important for us to keep pushing for this to happen, but recognizing that the where practicable is appropriate given where we are at this point and some of the limitations that are outside of operators' hands. And so very much am in support of this addition.
Commissioner Cross, and before I call you Commissioner Cross, just to further edification, the language here is taken from Reg 7. So it's consistent with CDPHE. So just FYI. Commissioner Cross?
Thank you, Mr. Chair. And I'll kind of take this back to a bit of a 50,000-foot view, I think, to start. And that's to say, I think generally I have a problem with prescriptive regulations like this. I think it's better to let those that are being regulated come up with the best ways to meet. That said, I do recognize that the statute also requires us to come up with these enhanced systems and practices and ways to do it. And so I do think that these are some of the things that will have large impacts on making sure that we meet our goals when it comes to greenhouse gas emissions, when it comes to NOx reductions, et cetera. And so I do have a problem with prescriptive language. That said, I do think that the use of the practicability, especially on this limited number of especially difficult, and as Commissioner Oath just said, those that are hard to obtain at times, not necessarily because of what the operator is doing, but more so because of things that are out of their control. Availability of rigs, ability to get power to the sites, et cetera. And so that said, I think that the practicability is a good way to kind of compromise on how this can take place and make sure that we are meeting our statutory requirements, making sure that we are protective, we are addressing cumulative impacts, we are addressing direct impacts on a lot of these as well, without making it completely prescriptive, and making sure that there are off-ramps where I believe off-ramps should be able to do it. That said, I think that, as will be shown in some of what's to come in this language here, I think it's important to show that not just for our own edification, but for the public's edification and transparency of our process, that it's not just, well, this wasn't feasible and therefore we're moving on. And it's come up several times in some of our previous hearings, but making sure that the public and the commission is aware of why these enhanced systems and practices cannot be done. And especially because they will have the larger impact. And so I'll kind of get off my soapbox a little bit with respect to the prescriptive regulations there, but I do think that the practicability that's to come is a good compromise for that. And I'm, with respect to the electric rig, as Chair Robbins noted, it being part of Reg 7 as well, I think that's a fine addition.
Others?
Chair Robbins, I wonder if I could ask a couple questions, because I need to better understand what type of engines are 50 horsepower and what are, I don't understand those engines, and so I'm having a little bit of hard time with the language. And I'm asking this because right now it says drill rig engines, and so I think that acknowledges that there are certain drill rigs that have their own engines that are associated with them, but we also see applications that include electric drill rigs, but those electric drill rigs are powered by fossil fuel generators. And so I guess I'm trying to understand, like, what does this exactly apply to if we're saying that it's that they can meet this standard by having 6 fossil fuel diesel generators generating electricity to power an electric rig. So do you see what I'm saying? I guess I don't totally understand, because I'm not sure that ultimately meets this goal if we're allowing 6 diesel generators to power an electric rig, because these 6 diesel generators are generating electricity. And so is there a loophole in here, I guess, that maybe doesn't meet the intent?
I used language that was proffered to me by stakeholders relevant to the equivalent language from Reg 7, and I felt like it made sense to use the same language. And I did not drill down, not to be a pun here, further into that, and so would wonder if Commissioner Cross, with his expertise, could try to answer that question, or perhaps elevate Tessa Sorensen to help get us an understanding of that. Apologies, I use language that was proffered to me by stakeholders from kind of both sides.
Yeah, and that's fine. I'm just trying to better understand the language and what is a 50 horsepower, what is not a 50 horsepower, what's typical for a drill rig engine, those type of things, because this is pretty prescriptive, not prescriptive, but specific, right? And so I'm just trying to understand it.
Commissioner Cross, I see you unmuted. Does that mean you're willing to take a gamble here?
And I guess I first like a little clarification. I don't think I was completely following. So you were concerned about numerous smaller generators being used together to power a larger rig?
Well, maybe the easiest thing for me to do is like walk through how this would apply, right? So, and I'm thinking aloud here, so bear with me. So it says that all new oil and gas locations subject to this rule, anywhere, if it's during the ozone non-attainment season, if practical, they will have to use a drill rig engine and or turbines with a manufacturer's design rate greater than or equal to 50 horsepower that are either utilizing grid power or non-fossil fuel generated power. And so I guess my first question is, what is considered a drill rig engine? And then my next question is, what if an operator is using fossil fuel generated generators to generate electricity to power an electric drill rig? Does that meet this standard? Because it's not, those generators aren't necessarily a drill rig engine, but I also don't know what the definition of drill rig engine is. Does that make sense?
I think it does, and I guess with respect to what qualifies as a drill rig engine, I think that might be best to leave for Ms. Sorensen, as it goes to a Reg 7 specific issue. So I don't want to try and speak outside my part.
Commissioners Cross and Messner, Ms. Sorensen is going to be ready and able to testify to this piece in 5 minutes. So can we maybe take a quick break and then give her a chance to get on board? She just chatted me that she will be ready in about 5. So it's time for a quick break anyway. Let's return at 10:36, and then we'll take this matter back up, and appreciate the questions. All right, welcome back. We are reconvening on October 10th at 10:37 of the Energy and Carbon Management Commission. And we now will recognize Tessa Sorensen. Were you able to hear the questions from Commissioner Messner on this topic?
Yes, Mr. Chair. The question was, from what I gathered, about what really a drilling rig engine is, and whether you could have an electric capable drilling rig powered by satisfying the engine requirement powered by fossil fuel generators feeding it. Is that correct?
I believe so. That sounds good to me. Commissioner Messner, are you thumbs up that that's the question?
It's a good starting place.
So the short answer is yes, that is a possibility. It is actually being done around completion specifically for frac fleets, which is not what your language here is talking about, but is where they're being called e-frac or electric frac fleets, and they have a central natural gas set of generators specifically for that purpose. As opposed to a natural gas engine, these would actually be natural gas generators, specifically generators, which are meant to be able to literally plug into a power grid and add to it. So it would actually do that, where you were burning natural gas to power that. Now, that said, that technology for completions is really, really new and not very available at the moment, but it is on its way and has been advertised by several manufacturers and service providers. In terms of drilling rigs, you could potentially do the same thing. There's no reason why you couldn't, because pretty much all of drilling rig equipment is run off of electricity, and that electricity is generated somehow. A lot of times that is those engines could be going to an electric motor that is actually moving the drawworks and powering the pumps and things like that. It used to be mechanically tied specifically to the engine originally to raise the drawworks, make the pipe move up and down, but that's not so much the case anymore in most rigs. So all the ones that don't are quite old at this point. So there's another piece. The third piece here is the language you could use to get away from that possibility, and that is to say that you want grid-powered drilling rigs. That specifically ties it to the electrical infrastructure, and it sounds like the proposed language you're considering has an off-ramp for an equivalent technology, basically non-fossil fuel powered. So I think that's kind of the key language, is saying that it's non-fossil fuel powered. This is different from AQCC's language. And give me a moment while I navigate to that. You know, you've looked at a regulation too many times when you have the page number memorized. So what we say in our cumulatively impacted community requirements in AQCC is that it is powered by grid power or non-fossil fuel generated power. And we actually say that pretty consistently, both for in a cumulatively impacted community and not. We say, and I'm quoting, drill rig engines or turbines with a manufacturer's design rate greater than or equal to 50 horsepower must be, and powered by grid power or non-fossil fuel generated power is the option there.
And that's the
As
language.
it says grid power and non-fossil fuel generated power, that eliminates that possibility.
And that's the language that I've suggested in the edit.
Okay, then I'm sorry, I was not reading your edit on there. As long as it's saying that, then yes, you are covered with that, because it's by grid power or non-fossil fuel generated power. If you had an electrical rig that had fossil fuel generators attached to it, that would certainly not qualify for that language.
Okay, well, let me just, because I'm just trying to get my head around this, right? So drill rig engine. So a drill rig engine could be a diesel engine, it could be a natural gas engine, it could be an electric engine. If it's an electric engine, I mean, the drill rig engine has to be powered by something, and I understand and I acknowledge that. And this 50 horsepower, as I guess, metric, is that designed to capture like the bigger oil and gas drilling rigs and not capture workover rigs or things lower than that? What is the significance of the 50 horsepower?
The significance ties back to the tiering system for diesel engines and other things of that sort, because one of the other options they can do in AQCC rules is use a tier 4 diesel engine. Now, tiers are controlled by the EPA. There's many of them, and it really depends on what the horsepower is before you even get to those tiers. When you're talking about this level, so you kind of had two questions there. The first is, does 50 horsepower only the big rigs? No, it's pretty much everything for that. It's just not the ancillary equipment that's on site. 50 horsepower is not much when it comes to that. So that's quite small. You could not, I don't think you could actually drill a well with a 50 horsepower rig. And the tiers, the way the EPA does it is they do it in terms of kilowatts. 560 kilowatts rated power or greater is what they're looking at, and that's where the tiering system comes from. So that's also why you never hear the term a tier 3. They don't exist for engines that are that large. It goes from 1 to 2 to 4 by EPA emission standards. So that's
really,
kind of
I think the root of my question here is, I mean, there can't be an oil and gas rig that is less than 50 horsepower with a drill rig engine of less than 50 horsepower. So this captures all oil and gas rigs. And that was really my question, because it wouldn't even be probable to like stack 6 45 horsepower engines in order to skirt this rule. It's just not possible. The drill rig engine is what it is. It's going to be more than 50 horsepower. And so this captures all the drill rigs as practicability standard. Is that fair to say?
Yes. So 50 horsepower is like 37 kilowatts. And most of these are 560 kilowatts plus. So we're talking an order of magnitude. And would it be conceivable to do that? I know I have personal friends who are electrical engineers who would say yes. Is it practical, or would anyone ever try? No. You couldn't really, not practically.
Okay. That's helpful. Thank you.
Yeah, you're welcome.
Okay, so we've talked through potential loophole, found there isn't a loophole, and the language consistent with Reg 7 is what's before us. Thank you, Ms. Sorensen.
From my analysis, yes, Mr. Chair.
Really appreciate your paying attention and being available for subject matter expertise. We need a healthy dose of that as we move through this.
CDPHE is always there for ECMC, absolutely.
Other questions, thoughts, concerns on this provision? And AG Stafford, if you want to bring it back up so that we can take a look at it, and then we're going to move to the practicability addition here at the end. All right, so let's move down to practicability assessment. This is current language. If you want to minimize it a bit, we might be able to see if we can see it all on one page. There you go. So it had AA, BB, CC, DD, and then I had some stakeholders asking for language around the alternative ways, other methods. The language that was proffered by some stakeholders, went and did the sort of the hierarchy, the first avoid, then minimize, then mitigate. I did not feel that was necessary, and it was duplicative, given that my direction has been that for these things, we're going to put into the SBP that the hierarchy is first avoid, then minimize, then mitigate. And so I didn't feel a necessity to restate that here. It does talk about avoid, minimize, and mitigate, and it talks about other methods. So that's where I landed in terms of this additional assessment in terms of what practicability means. And just in the for what it's worth category, I like this approach. I don't know that practicability is defined in case law, and I like us defining things in our rules so that we have a clear picture of what it is meant when we say this. And then this is how commissioners we will interpret when someone comes up with something's not practicable, and we've got a good definition here with 5 sub elements. Questions, thoughts, concerns on this language? All right, not seeing any, then I think that gets through the edits that I had on 316. AG Stafford, where do we go next?
I can bring back the, I guess, master draft, and we'll move to 316D.
Mr. Chair,
Yes.
I could be misremembering, and now maybe I'll pull it up, but you had in your explainer document, my recollection was that on the very first page, there was a note about 316D. Provision in 316D having to do with a may to a will.
Oh, yeah. It's right here. It's this may here at sub D1, that director may require the operator. That turns into a will. And then the lists for pre-production and production at A and B are what remains at the discretion of the director in terms of what the actions are. So it's not that there is it becomes mandatory that actions are going to be taken, but the director retains discretion as to what those actions are. Thanks for that catch, Commissioner Oath. That was kind of a late breaking development.
Thank you, and I will just say it was notable to me because I think it is important. It does go with kind of the previous conversation of mays to will, and I would support this change. I think that it makes sense that in the case that there has been either previous noncompliance or not a demonstration of ability to comply going forward, that this is the appropriate role for the ECMC to step in and in that case kind of prospectively to ensure that future noncompliance does not occur, and that, you know, there's discretion there to determine what type of action is necessary to make that happen. But I think that this change makes that purpose.
AG Stafford, do you want to just type that in real quick, those change of those 2 words so that it's evident to all?
Thank you, Chair. And just, I think I'm looking at the explainer document. I think maybe is this D or D1?
D1.
It's D1.
Gotcha. Okay. Apologies.
Thanks. No. Yep. Commissioner Oath, that's consistent, right?
Yep, I agree.
Anybody have concerns or thoughts on this last bit of an edit here? I can't see you, so just pipe up. All right, hearing nothing, then that edit is suggested to the draft as well. Anything further here, AG Stafford, that we need to focus in on?
I do not believe so, unless anyone has additional edits to 316D.
All right, I'm not seeing any. Where do we go from here?
Chair, if you'll recall, this particular document does not include your other suggested rule revisions, so we could potentially move to any changes commissioners have in I think it's Rule 803, 904, and then I think 1201 was really only adjusted because we had to change a rule reference. But if anybody has changes in these, they should be fairly quick to deal with.
Okay, sounds good. So on the table are the 8, 9, and 12 series. Commissioner Ackerman, if you're trying to articulate something, you're muted.
Thank you. Thought I clicked off. Can you hear me now?
Yep.
Thank you. Yeah, I do have some discussion around 904, but not language concerns, but wanted to note some basis and purpose suggestions. We've included, and I appreciate staff's work on this, we've included CPW as a specific consultative party. And I wanted to reiterate my thoughts as we talked about this during the hearing, that in my opinion, the intent of the director meeting with CPW and CDPHE would be to consult with those agencies prior to finalization of the director's annual report. And one of the specific items of discussion should be whether any cumulative impacts identified in the report warrant consideration of additional actions by the commission. This was kind of my thought with regard to the concern or watch list in which CDPHE and CPW can highlight and identify issues that are causing them concern and talk with the director about a plan to address those issues and the need to address those issues. Same with regard to the inclusion of reclamation, and I appreciate the inclusion of reclamation here. I think I added an additional clause at the end of 904(1)B that's not showing up in this draft. So I just want to make sure that that made it in, and I can dig that back up if I need to, but I believe that notes were taken there. I wanted to reiterate that point. And the intent would be to summarize reclamation status in the state, both annually and overall, including completed projects, status of uncompleted reclamation projects, acreage remaining disturbed in oil and gas developments, and to the extent possible, the type of habitat remaining disturbed. And as I mentioned earlier, I'm certainly interested in continuing to work with staff on this issue in conjunction also with the surface disturbance issues that I'm volunteering to work with them on. So just wanted to make sure that those points from my perspective were suggested for inclusion in the basis and purpose statement, and certainly open to further discussion or ideas from other commissioners.
Thank you for that. Other commissioners with thoughts?
I'll just chime in to say I really appreciate that, Commissioner Ackerman, and I think those are important considerations and things that need to continue to be considered, and that objectivity and the utilization of the data that's being provided in the CIDR database and Form 2Fs. I think I would encourage us to and it would be great if this was captured in the statement of basis and purpose, to continue to find ways to make the CIDR database compatible with some statewide tool that would take this good information that's being developed and make it in a format that is actionable by the commission in our decision-making processes. And I think that the end of year evaluations are great. I think it gives us a snapshot in time, but we are starting to develop a database of information that I think can be utilized to help us make decisions on evaluating and addressing cumulative impacts, and needs to be tied into other statewide tools that are available to ultimately improve our decision-making processes. And so, so anyway, long way of saying, I think you're on the right track, Commissioner.
I appreciate that. Agree as well. Others with thoughts?
Chair, if I might explain why we didn't include some language in 1B.
Yeah, please.
And I think staff has, or Ms. Trask spoke to this multiple times over the course of the hearing. I think staff isn't in, staff feels it would be appropriate to have further discussion on many of the issues that Commissioner Ackerman has brought up, and doesn't feel at this time that some of those edits are appropriate for rule edits. I think we can capture those things, those intent, in either continuing further discussions or continuing to develop ways to collect the information that I know the commission is looking to see in SBP language, but I think at this point staff does not feel comfortable putting something in rule language to the effect of what is being suggested here. And I would say we can obviously table this for discussion with Ms. Trask later. But I want to reiterate staff's perspective here, which I think Ms. Trask has done a pretty good job of bringing up over the course of the hearing.
Commissioner Ackerman?
Yeah, thank you, Mr. Chair. I certainly do recall us having those discussions associated with the inclusion of requirement for GIS polygons. I believe Ms. Trask did talk about trepidation. It may be slipping by me, AAG Stafford, but I don't recall that same discussion with regard to this issue. The clause that I was suggesting at the end of B, because right now it just says information regarding reclamation during the prior year. I don't think that's a sufficient evaluation of cumulative impacts of the reclamation work that's taking place in the state. It does say including wells and locations that achieve final reclamation, so the focus on final reclamation. What we're also looking for here is the status of all reclamation work throughout the state. And so with the clause information regarding reclamation during the prior year, I get that that's a little bit vague, but does only include prior year reclamation work. What I was suggesting as a terminal clause is and status of other pending reclamation work, which is, relatively comparable to that, but includes work that's going on that's not taking place in just the prior year. So again, I don't recall staff trepidation. That's new information to me, but I also would appreciate maybe some further information or explanation as to why reclamation shouldn't be included in the cumulative impacts report on a broader basis than just during the previous year.
With that statement, Commissioner Ackerman, are you good that we could possibly continue this discussion at 2 when we get back with Ms. Trask?
That would be fine, Mr. Chair. And I do have one other parking lot issue that I alluded to as well.
Go ahead.
We talked earlier the day before yesterday about red line language also for potential operator surface disturbance inclusions. And so the commissioners should have that in their inbox as well from AAG Davenport. And I think it's appropriate to talk about that when Ms. Trask is here.
Everybody comfortable with that? Anything else on this to go through at this point, Ms. Stafford?
Not in this particular document, Chair.
All right. Do we want to roll into the 604 document that I put forward? All right, commissioners, and I've introduced this to you previously, but we'll just sort of walk through the red line edits here. Again, certain stakeholders wanted the avoidance, minimize, mitigate hierarchy to sort of be stated at each one of the criteria. I would rather and believe that it's appropriate to put that in the SBP, and then we wouldn't have to then re-establish that in the actual language of the setbacks that are set forth here. So that's the first point there. The second point is comment bubble that's not illustrated right now, but it's right there. Oh, there we go. That we're just clarifying that the 604B 1 through 3 continue to apply. And then clarify in the next bullet that operator seeking to do 604B2 would need to do this additional some form of additional notice between the issuance of director's recommendation and the actual hearing date. I had put in a 30-day provision here so that the DIC community would have that ability to make sure that they understand what has been proposed by the director in this. Obviously, all the additional clarifications and notices and consultations continue to apply in all of those provisions. And just by way of additional edification, certain stakeholders, and if you can go back to the left there, AG Stafford, wanted to remove completely the comprehensive area plan off-ramp, not only for DIC, but they wanted to remove the comprehensive area plan off-ramp for every single OGDP. I'm not in favor of that. I believe that we need to incentivize and continue to incentivize comprehensive area plans. I believe that moving forward, as we look at comprehensive area plans, we're going to be looking at it with the cumulative impacts in a DIC lens. I think that utilization of a comprehensive area plan continues to be one of the best practices that we've created in Colorado. It allows for a large-scale approach to looking at things and large-scale approach to dealing with cumulative impacts. And so I'm still in favor of leaving that as an off-ramp, and certainly not in favor of removing it for general OGDPs as well. So the next edit, I'll just walk through these and then we can come back and have a discussion if it's necessary. Over on the next page, certain stakeholders had desired that the efforts around informed consent be best efforts. Others had wanted just to remain at just efforts or good faith efforts. And I believe that the appropriate place was to land at undertake all reasonable efforts. And so that's the language that we would find on the next page in two different places. And I believe those are the final edits that had found their way into the document between the last iteration and today. Yeah, there we go. Commissioners, thoughts, questions, concerns? Commissioner Cross?
Thank you, Mr. Chair. I'll start off, I think, with the 604B exception that you mentioned, particularly with respect to caps. I understand the point of that. I agree with you that I think it's good to incentivize the caps to make sure that happens. I think it's also important to recognize that our additional rules will still apply. It's not as though the Rule 316 ESPs are not going to apply. If it is in a disproportionately impacted community, we're still going to have those same ESPs, the same BMPs that we require already. So I don't think that that's going to change what's currently required elsewhere in our regulations. And so I guess I'll start off saying that, but I think it's important to note that there's still going to be the protections, even if that kind of exception, as it was called, is not adjusted.
Appreciate that point. Do you want to continue with anything?
I'll say so for 604B4B here within the DICs, I'll say my biggest concern is kind of I don't know if we want to call it a negative inference here, no finding of substantial equivalence unless. I think to me, it's more of a concern of multiple standards. We talk about in 604B4A, we have it's broken out into substantial equivalence determination will be made based on. And so now we're saying a substantial equivalence determination will be based on, and then we say, however, there's not going to be a substantial equivalence determination unless there's also a demonstration. And so I just have concerns with the kind of dual standards here as to what we're looking at. And that's one of the things that stuck out to me. And I know I mentioned that when you first daylighted this language last week. So that's one of the things that stuck out to me. Otherwise, with respect to the addition of the considerations, what is there, 16, I believe it is.
If you add up the A's and the B's, it
Yeah.
equals up to about 16. Yes.
Yeah, I'm comfortable with all those. I do agree that, I think it's appropriate to take that harder look, especially in disproportionately impacted communities. And so I think making sure that this information is provided, this information is considered. I do think that it's appropriate to have those in there to highlight that the enhanced systems and practices that are going to be used to avoid, minimize, and mitigate. I do think that those are appropriate additions to the substantial equivalence determination and providing a little bit more detail on what we're looking for.
Yeah, no, I appreciate you highlighting those points, Commissioner Cross. And there was a lot of discussion and debate between stakeholders to me on the sort of that Romanet 1 the initial demonstration under AA through DD. Some stakeholders had, I'm just, being honest here, some, major concerns about that. Other stakeholders felt that because this is a substantial equivalent standard for DI communities, that having that sort of qualifying element really provided that level of robust protections that are necessary for DI communities. I made the call to sort of, I felt like that we should leave it, that we should undertake that. I also would explain to commissioners that Romanet 1 and Romanet 2, in my opinion, are to be debated and deliberated upon by commission at one time. And that, it wouldn't be that you have a hearing on B Romanet 1, and then once you have that hearing, then you go to B Romanet 2. I think that we would take all that up in one fell swoop, and that makes sense. And that's something that we have the capacity to undertake. And so I'll believe that, while this is definitely sausage, that it is the appropriate place to land on these points in terms of creating a robust, protective, substantial equivalent standard that is allowable for operators to potentially bring to us. And then ultimately it's for us to make the determination of whether they've proven it up via the Romanet 1 and Romanet 2. With that, any other thoughts, questions, deliberations, et cetera, from commissioners on this point?
I have a couple, just one actually, if I could.
Go ahead.
So I really appreciate the work that was done on this. I think that this additional substantial equivalency protections that were developed for disproportionately impacted communities are, as you indicated, robust and above the substantial equivalency that we developed for oil and gas locations that are sited inside 2,000 feet. Outside of disproportionately impacted communities, as part of our initial mission change making, I think that the substantial equivalency that we developed with our initial rulemaking, mission change rulemaking, I think it's a good standard, and so support that. And so I just want to acknowledge that I think that this substantial equivalency for DIC communities is strong and it's robust. I think the existing substantial equivalency is strong and robust and allows us to make those determinations. I'm comfortable with. So let me start that during the mission change rulemaking, when we created caps, I missed that we created a situation where substantial equivalency would not be applied to locations that are inside 2,000 feet within a cap application. I think this is no hidden thing. I think I've expressed that since the mission change rulemaking. I think that we determined that we needed to utilize substantial equivalency because it was necessary to protect public health, safety, welfare, the environment, and wildlife resources, and that it, in my opinion, should be applied both to, should be applied to any application that is inside 2,000 feet, based on the record that we developed during the mission change rulemaking. And so that is not up for debate in this rulemaking. I understand that it's an existing rule, and so I'm not suggesting that we make any changes to that rule at this point. However, I do think that as we look at substantial equivalency application in disproportionately impacted communities, it would be, in my opinion, a mistake to not have that apply to applications that are proposing operations inside 2,000 feet in disproportionately impacted communities as part of a comprehensive area plan. And again, the rationale for me is the same. We've made a determination that these are reasonable and necessary to ensure protection of public health, safety, welfare, the environment, and wildlife resources. And I agree with that, and I think that they are robust and necessary and meet the obligations of the Act. And I also agree that comprehensive area plans are a good thing, and we need to create both incentives to utilize them, but also ensure that we are being protective of public health, safety, welfare, the environment, wildlife resources. And so I'm not sure it's appropriate to create incentives for caps that may potentially impact public health, safety, and welfare. So I'm all for creating incentives. I'm all for caps. I think that they're a good thing, but I'm uncomfortable not applying the substantial equivalency standard, which is certainly meetable, right? And so I don't think it's saying that it's not possible to have these things inside 2,000 feet in a comprehensive area plan. But we just have to apply the rules that were developed with the record and the rationale for why they were developed, both inside and outside of cap applications. And so, so I make that suggestion as the only change I would make to the proposed rules.
Thank you for those thoughts. Commissioners have heard from me on this. I believe that as drafted, this is the appropriate landing place, which includes continued with the off-ramp on caps, noting that it does establish that incentivization. I think that when we're looking at caps, we're looking at additional protections globally for the areas that cannot occur on a singular OGDP, and that is a preferable value add that you wouldn't get by just using the substantial equivalence on a one-by-one OGDP approach. And so I continue to sort of advocate that this is the right landing spot, but I would love to hear from my fellow commissioners on the point raised by Commissioner Messner. Commissioner Cross?
Thank you, Mr. Chair. And I completely understand where Commissioner Messner is coming from, but as you just noted, I think that there is a stark difference in caps versus the OGDPs overall. And I think especially where we're trying to incentivize the preliminary siting for caps, we're looking at the cumulative impacts on the entire region level, the cap level. We're looking at the cumulative impacts on the specific site-by-site level. So the way we're looking at it now, we have that cumulative impact analysis. We have the alternative location analysis. We have the different 2F and 2B submissions trying to talk about what's going in. And again, I think it's important to recognize that there are going to still be the additional protections for disproportionately impacted communities. There are still going to be those additional protections for RBUs overall, especially if we're looking at where we've seen the caps thus far have been in the DJ Basin and in the non-attainment area. We're still going to have those ESPs taking place. And so to me, I think that to go back and kind of change that incentive that we had in there beforehand doesn't make sense when we still have the protections that we're trying to do here. And so I think that looking at the cap, not under a substantial equivalence if one of the sites is done with it, but looking at the cap as a whole and with the protections that the cap provides and with the analysis and evaluation that the cap provides, I think is an important way to look at it. And so I do understand where Commissioner Messner is coming from and not trying to say that it's a way to get around substantial equivalence or anything else. I think it's just important to note that there's still those protections under 316, under 315, under 304 that are still going to apply to those locations that are within the cap.
I'm muted. Commissioners Ackerman or Oath, care to weigh in on the topic? Commissioner Ackerman?
Yeah, thank you. I've actually given considerable thought to this one as well. And, this is a difficult issue. We certainly have been tasked with protecting DICs. I think the regulations that we've put forth recognize our commitment to doing so. This is one of the concerns that has been brought up on a number of different fronts. And to me, what it comes down to is ensuring that we have adequate data, adequate information, and an adequate analysis of the sites in the cap process and at the cap level to ensure that we are proactively making that decision as to whether this, I don't want to call it an exclusion, this off-ramp will apply, and understanding that it will, and ensuring that we have appropriate community outreach during the cap process in order to make sure that nobody's surprised. If those things are taking place, then I'm in favor of leaving this off-ramp on, as the chair has suggested. I think it requires diligence on our part during the cap process.
Thank you for those thoughts. Others desiring to weigh in? All right, seeing nothing further, I believe we don't have consensus here. AG Stafford, did you have something to provide?
No, Chair. Apologies. I was just revisualizing myself.
No problem. I guess what I was wondering is we've not run into a situation where we've not had consensus. I think maybe, having a little straw dog vote maybe would make some sense to make sure that we're going in the right direction. So those that are in favor of the position that I've put forward relative to keeping the cap as an off-ramp, noting that the additional protections would continue to remain, sort of raise your hand there. And then those that are in favor of Commissioner Messner's idea of removing the cap for DIC, we would need to sort of figure that out. So are you comfortable doing it that way?
I'm comfortable doing it that way. I want to reiterate, I'm not asking to remove the cap. I'm just saying that substantial equivalency would apply both inside and outside of the cap. That's all I'm saying. And again, caps can be done in disproportionately impacted communities. They can be done outside disproportionately impacted communities. It's just the applicability of the substantial equivalency standard, which would still allow for applications to site operations inside 2,000 feet in a disproportionately impacted community. They would just to meet the substantial equivalency standard. And I would also, just for the future knowledge, advocate for that in a future rulemaking for application outside of disproportionately impacted communities, because I think that substantial equivalency concept is a good concept. And I think it's one that was debated during mission change. And it makes sense to me just from a procedural standpoint to equitably apply the protection standards that we developed during the mission change rulemaking for applications inside 2,000 feet, irregardless of what type of application it is. And so I acknowledge, as Commissioner Cross indicated, that there are additional evaluations that happen and submittal requirements that happen inside caps. In some situations, there's less submittal requirements that happen inside caps as part of our incentivization of caps. I think we've seen some amazing caps, and I think we've seen some that are a little more challenging. And so I also agree with Commissioner Ackerman that if we, equitably apply all of the rules inside of caps and we take that responsibility on ourselves, it is possible that we can accomplish the same thing as substantial equivalency, but there's nothing in the rules that requires us to do that. And so I'm just trying to equitably apply the procedural standards that we developed in the mission change rulemaking for any application inside 2,000 feet. So I'm not trying to discount anyone else's opinion. It's just the way that my thoughts are. So thank you.
And so I guess I'm sorry if I'm struggling to understand what your position is, Commissioner Messner. Can you explain in sort of, are you trying to suggest that we remove 604B2 and you always use substantial equivalence irrespective of whether it's in a cap or not?
What I'm suggesting for this rulemaking is that substantial equivalency, that the 604B2 not apply inside disproportionately impacted communities, because that's one of the goals of this particular rulemaking. If I had my druthers for all the rules, even the ones that aren't being noticed for this hearing, it would be to remove 604B2 and apply substantial equivalency anytime an application includes operations inside of 2,000 feet of RVUs, only because we developed that record in the substantial equivalency because it was necessary and reasonable to protect public health, safety, welfare, the environment, and wildlife resources during the mission change rulemaking. And to be honest, Chair Robbins, I missed it during the mission change rulemaking that it would not apply inside caps. And after the fact, when we were applying it, is when I realized that that would not apply inside caps. And otherwise, I would have brought this up more clearly in mission change. And so that's on me. But that is my opinion.
So for this rulemaking, you're suggesting 604B2 be removed for proposals within 2,000 feet of a DIC or an RBU in a DIC.
That's correct.
Okay. And then just so that I understand, if we got to another rulemaking around 604, you would apply substantial equivalence to every location within 2,000 feet of an RBU, and you would remove not only 604B2, but you remove informed consent and 604B3, which is the emitters in the tanks.
No.
That's what I heard you say.
All I said was substantial equivalency. And so
yeah, but I think I heard you say that substantial equivalency would be mandatory for any RBUs within 2,000 feet.
Well, it is already in OGDPs, right?
No,
unless they have informed consent, right? So you would keep the others. You would keep the other off ramps. You would keep 604B1. You would keep 604B3. You would keep all the other off ramps.
Okay, all right.
But you would still have to apply substantial equivalency inside of a cap. That's all I'm saying.
Okay. Well,
and I'm not trying to apply the DIC substantial equivalency standards to anything outside of DICs. That's not what I'm saying either.
Right. So the question before us right now is whether to apply 604B2 to DIC. So that on the one hand, does CAP have an off ramp or not for new locations within 2,000 feet of an RBU and DIC? Is that fair?
Oh, sorry. That's correct. Yeah.
Okay. So that's Commissioner Messner's place, and we need to sort of, work through this so that we can give appropriate direction to staff on this point. I'm not in favor of that, as has been articulated and is in the draft that I put forward. I believe Commissioner Cross is not in favor. Commissioner Ackerman and Oath, we need to kind of get a sense of what your perspective is on this issue so we can provide a majority direction to staff and then be able to move forward. Commissioner Ackerman?
Thanks. I'll restate to make sure that I'm clear, Mr. Chair. I get where Commissioner Messer's coming from, and this inclusion in the cap has caused me some trepidation in the past as well. And that said, it currently is an off-ramp in our rules. I think you've added specific protections to DICs that help us further mitigate any concerns associated with those kinds of placements in DICs. I do think it's incumbent upon us to very strongly examine all caps that come in and intend to use this provision so that nobody's caught off guard at the OGDP stage. I think that goes as well with DICs in the language that you've suggested with the additional protections. And so I'm in favor of the language as it's included.
Commissioner Oath?
Thanks, Mr. Chair. And I know I've been notably quiet during this conversation. I am struggling on this issue, and I think I'm remain on the fence. I think all of you have made really good points, and it appears I don't need to necessarily pick a side of the fence here to provide majority direction here to staff. So, with apologies for staying abstaining or staying neutral, that's where I am on this straw poll.
Okay, fair. And that's why we're a 5-member commission, is to bring in the expertise of 5 different heads. And so with that, I think we have direction to AAG Stafford that we will move forward with the language as drafted, with the caveat that in the 300 series, we put some additional direction between the director's rec on a cap site-specific OGDP, so that we ensure that there is a 30-day provision between director's rec and the actual hearing on that matter to provide additional insurance that the DIC is aware of the direction that the director is pointing us to. And then with that, we did get through the 8, 9, and 12. I think we've gotten through the draft between current language and current rule. Are we at a point, AAG Stafford, do you think, and or AAG Davenport? We've still got a parking lot, and we've still got Ms. Trask coming back at 2. Are we at a space where we should break and let staff? That would also give you, Ms. Stafford, the opportunity to weave in the proposals that I had put on the table that I believe we've got consensus on, at least majority consensus on, into the draft, and then we could come back and revisit with Ms. Trask the parking lot elements, or are there other things that we should take up at this time between now and then? I guess that's a question to all the commissioners too.
Sheriff, if I may just get some brief clarification on the addition to the 300 series that we are making.
Yeah.
I'm sorry, we've been trying to capture that and didn't fully capture it.
That's with regard to a proposal that's utilizing the 604B2 cap off ramp.
Okay. Yes.
Mark. Yeah. What I had proposed, and some stakeholders had concerns that if that was going to remain in, there is a concern that under current practice, we try to have and Ms. Trask would clarify this, but I talked to her offline. Staff tries to have the director's rec go out and then have ahead of a 14-day window between that and the actual hearing. But there are times when that doesn't happen. And there are times when we've gotten a director's rec on a Thursday or Friday before a Wednesday hearing. And I wanted to create an assurance that if someone is attempting to use the 604B2 for an oil and gas location within 2,000 feet of an RBU and a DIC, that there would be a mandatory 30-day window between director rec issuance and the actual hearing date. That way, the affected RBU DIC community would have an opportunity to understand, and I would want the community liaison to be a part of this to ensure that there's an understanding about what the director's rec is when that off-ramp is utilized. So that's the direction that I was going in my bubble comment over to the side.
Thank you. I appreciate that. I think we got it now.
Okay, hold on. Commissioner Messner wanted to weigh in.
Not on that particular point, but I agree with you that that's a good inclusion into the rules. I would like to put in the parking lot for discussion later that a similar concept associated with director's recommendations in general around a 14-day timeline if it's outside of a disproportionately impacted community, for similar reasons to ensure that the relevant stakeholders, the public, as well as commissioners, have an opportunity to review that director's recommendation, compare it to the application, and be prepared for hearing. But I want to understand whether or not that is a problem from a process standpoint for staff. So,
okay, so I appreciate that point. AAG Stafford, if you could put that in the parking lot as well, and between now and then try to alert Ms. Trask that we'd like staff to weigh in. Basically, I think what that's doing would be rulemaking codifying the principle that staff tries to do now, which is the 14-day window. But right now it's a notion and not a rule. And so let's put that in the parking lot for a discussion with Ms. Trask as well.
Got it. Thank you.
And Ms. Stafford, not to put too much on you, and I know, Lord, we've put too much on you for the last few months, and I do hope you get a quote vacation and not just going away at times. But if you have the parking lot in a written form, if you could share that to us, that might help us as we get prepared for the 2 p.m. session.
Thanks, Chair. We have some notes going right now. I have another member of staff helping me with that, and we can try and put that into a more digestible format.
That would be tremendously helpful. Thank you. All right, commissioners, anything else at this point? All right, seeing none, we will continue this hearing until 2 p.m. today, October 10th, and we will come back at that point in time and go through the parking lot. Thanks, everybody. Okay, welcome back. Energy and Carbon Management Commission, 2 p.m. on October 10th. We will continue with docket 240600145, the Enhanced Practices and Cumulative Impacts Rulemaking. If we could stop the screen share, that would be helpful.
Chair, I'm not seeing a screen share. It might just be on your screen.
Oh, it's just on. Okay, now it's gone. Interesting. Not sure what was happening there. Okay. And it looks like we've got Ms. Trask back with us. Thank you, Ms. Trask, for reconvening with us this afternoon. As promised, we created a Sabrina Trask parking lot, and we are going to go through issues that are on that list at this point in time with you and with your expertise in hand. So would ask Ms. Stafford to visualize and help us with the issues that we need to tackle this afternoon.
Thank you, Chair Robbins. I can screen share and show this Word document, or I can just read it to you so that you can see everybody as they're talking. I don't know what you prefer.
Why don't we try the reading to start with and see if that works?
Okay. So the first thing we have in the parking lot here is Commissioner Messner's proposal to include the transportation corridor language suggested by the allied local governments in the cumulative impacts analysis, it would be new rule 315 B2E Romanet 8.
Okay, and so to frame the issue, since this was Commissioner Messner's issue, Commissioner Messner, do you want to reframe it for everybody here?
Sure. Give me a second. I gotta get. So conceptually here, understanding that, within this section are different resources to be evaluated. There was a suggestion by the allied local governments that transportation corridors be one of the things that potentially could get evaluated. Understanding that, I think I indicated before, there's certainly some kind of push and pull around jurisdictions associated with transportation corridors, whether that's federal, whether that's state, whether that's county, whether that's municipality, but still seeing some benefit to evaluating the incremental cumulative impacts associated with potential impacts to transportation corridors from a new proposed oil and gas operation. It seemed perhaps valuable to evaluate that, or ask an operator to evaluate that as part of their overall evaluation for cumulative impacts, both as a tool for us to review it, the operator to review it, but any other party that may be interested in that aspect of an oil and gas plan as well. Understanding that some local governments may already have an expectation for this within their local processes, and so some substantial equivalency may be available to an operator and providing information associated with this, but saw some value in that. And so understanding that the staff didn't considered it, but chose not to include it, I was curious about kind of thoughts around that, and whether or not there is value in including that.
And Ms. Stafford, so that we understand, so I heard Commissioner Messner speak to transportation corridors evaluated. Do you have this language from the ALG that you could share?
Sure thing. Give me one moment.
So since we have the expertise of Ms. Trask and understanding that Ms. Stafford and Ms. Trask thought about this but chose not to include it, could I get some perspective from staff on this language and the competing value, add or not, relevant to it?
Yes, happy to weigh in, Chair. I think that the information being requested here does add value. I would hesitate, as Commissioner Messner mentioned, all of transportation is outside ECMC's jurisdiction, so this would be information that would largely be dictated by the relevant local governments. And so I wouldn't want to indicate any sort of presumption that we are overstepping our regulatory authority. I think the information, though, is valuable. My, I guess, sort of administrative concern is that where it is proposed to live in the draft rule, I would prefer to see it not listed in the same category, I guess, as the resource impact descriptions that are required by statute. I think it's important to separate out air quality and water quality and impacts to climate and noise and odor and wildlife and biological resources, sort of highlight that in its own set of the rule, which I think is subpart E here. And then if we wanted to add this in, this could be, the transportation piece could be added into a new subpart below, sort of separately from those statutory requirements. That's just my opinion. I don't think it's critical where it lives in the rules. I guess I just like to see have our rules very clearly demonstrate how this agency is complying with statute. And so by having this, if it does get added in, I would just recommend that it gets added in sort of at the next subset below, which I think would be F, the F on the screen, and then that existing F would just get bumped down to G.
Okay. Thank you. Thoughts from commissioners? Commissioner Cross?
Thank you, Mr. Chair. And I also think that this could be value add. I guess in some ways, I'm curious, Commissioner Mester, how you think of this as differing from some of the information we currently require with respect to truck trips and maps showing haul routes, etc. I'm just hoping to understand better the level of information you're hoping to get from this.
Yeah, I think it's a good question. I think the information that's provided as far as truck trips and haul routes is certainly valuable information to better understand the direct impacts associated with a proposed oil and gas operation. Again, I think in this section, we're looking at the incremental cumulative impacts associated with that. And so having a better understanding of current state, I think aids us in our ability to evaluate the potential cumulative impacts associated with transportation. And, to me, that ties to the act and to the mission by acknowledging that truck traffic and transportation, of operations proposed in an oil and gas plan or a comprehensive area plan do have the potential to create incremental cumulative impacts associated with that item as it's associated with public health and welfare. And so that's kind of how I see this tied in. So again, we look at direct impacts and now we're looking at cumulative impacts. And so they are different, but certainly speak to one another.
So essentially really just trying to get an understanding of what else is happening in the area of evaluation beyond just the operator's proposed haul routes and truck traffic.
Yeah, I think that's fair. I think that's really what every resource evaluation in this section does.
Okay, that's helpful. Thank you.
I'm comfortable with this as long as we, note within the SBP or otherwise that, this is just an information sharing and that this is not, generally this is a local government issue. And I want to be sensitive to that, but noting that the ALJ or the ALG is an affiliated local government group, I assume they don't have a problem with this given the fact that they've advanced it. In other words, and I like the idea of substantially equivalent information so that the operator's not having to sort of redo it, because I do know that this is the kind of stuff that local governments do address. Is transportation corridor, is that a defined term?
No,
it's not a defined term in our rules, but in that header there, it would be capitalized just because of the way the headers work.
Yeah. Okay. And I guess it's sort of defined as what's in AA and BB? Kind of self-defined that way?
I would say so.
Okay, so anyone with any heartburn if we instruct staff to weave some of this in? All right, then I think we weave some of this in. I would like that weaving to include some SBP language around what our jurisdiction is, and that we're not trampling on local governments, and like we can't adjust the AA and BB, but we can look at the information as part of our cumulative impacts analysis, if that's fair. All right, Ms. Stafford, what's next on our Trask parking lot? You can see I'm getting enjoyment of calling it the Trask parking lot.
The next thing on my list is Commissioner Ackerman's request to add additional language to draft Rule 904 A1B to include reclamation status in the state regarding completed, uncompleted acreage remaining disturbed and the types of habitat remaining disturbed. So I guess interim reclamation information.
Commissioner Ackerman, do you want to lead here?
I'd be happy to. Thanks, Mr. Chair. I appreciate it. And thanks for revisiting this issue. I'd certainly been pondering over the break your comment as chair to start this meeting that there are a lot of novel and complex issues that are certainly being thrown at staff in rapid succession here. And certainly appreciate staff and the AG's office. They have a difficult job to help us whittle those ideas down into processes and procedures and what we can do and what we can't do. And I appreciate a large number of our staff behind the scenes working with Ms. Trask in the AG's office to help us as we, fly through these hearings. My framing in 904, and I appreciate the inclusion of the of final reclamation during the prior year being part of the cumulative impacts report. I think that's a great step forward. I think that it also it would be very beneficial for us on an annual basis to understand what reclamation looks like in this state from a broader perspective. And so kind of my goals here are to get our arms around consistent reclamation reporting. The last comprehensive reclamation report we did as an agency was quite some time ago. And I think, keeping it in the forefront on the annual report is responsive to our constituents, but also the appropriate thing for us to do as an agency. And so my intent here is to really get everything into the report that we currently can do and require that that be placed in the report. And as I had noted before, I'd like to work with staff subsequent to these hearings, as I know they're currently working on improving processes and information management to help improve over time our reclamation reporting data. And so from that point there, if you wouldn't mind, Ms. Trask, I'll kick it to you to give us some thoughts on maybe what we can do beyond reporting on final reclamation for the last year that we could include in the regulation right now, and then maybe some discussion about how we can move forward in improving processes and procedures.
Yeah, thank you, Commissioner Ackerman. I think as we've discussed here, and I'm looking at some draft language, I'm not sure, Ms. Stafford, AAG Stafford, can you show the current draft 904? I think it's 904A1B, that if I'm looking at the right spot, I want to just make sure that what I'm speaking to is accurate. Thank you. So we currently would be able to include in the annual cumulative impacts report information on how many wells are plugged how many locations have achieved final reclamation status. That would be after a reclamation inspector has gone out and inspected the location. We do have those numbers currently, so that's an easy add into the report. We could potentially also provide numbers on the number of locations for which a final reclamation status has been sought by an operator. We don't always have a fast opportunity to get reclamation staff out there. And so normally there can be a little bit of a lag between when an operator says, hey, we're ready for final inspection, and when our inspectors actually get out there and do that final inspection. So I don't really want to speak to what that lag is, but I can say that we do have that information already in the database. The process is that when an operator finishes their final reclamation on a location, they submit a form that says we're ready for inspection. And so we could use that data. It's already in the database. It's queryable data to get an indication of how many locations are ready for that final inspection. So maybe I'll just stop there. I think that's something that we can answer. And then if we wanted to talk about adding to the report information about acreage, so the number of acres reclaimed, that gets a little bit trickier. Any location that was permitted through a Form 2A, we could use that Form 2A's maximum disturbed area. That's a data field on the Form 2A, and just sort of use that as a proxy to say when a location has achieved final reclamation, we look at the Form 2A or reference query back to the Form 2A to see what was that original total acreage of disturbance. We could do that now. We have that capability. The problem arises for locations that were permitted and built prior to 2009. The Form 2A didn't exist prior to 2009. And so for locations that were built prior to 2009, we don't have that any sort of data field in the database that says this is the area, the original total disturbance area. So in order to get that sort of information from an operator, I do believe we would need to revise the 1000 series, which is the reclamation series. That series has not been noticed in this rulemaking, so I don't think we can go there. So I guess short answer, what's shown on the screen here in green under subpart B, we can do that in the annual report. We could also add the acreage of reclaimed area for locations that were permitted and built after 2009. I don't think we can do much beyond that at this point without either revising the 1000 series or without some sort of brain trust with our reclamation team to figure out how else we might be able to achieve that data.
So thank you, Ms. Trask. I really appreciate the elaboration on those points. It's very helpful helping us understand. And again, I want to reemphasize that I know staff is continuing to work on improving the data that we're gathering and the opportunities that we have to report it. It occurs to me, and Ms. Stafford, AAG Stafford, perhaps you can help me out with this or give me some thoughts on this. It occurs to me that this is a bit of a different kind of regulation in that we're kind of regulating ourselves here and regulating what we're reporting. And so I don't know that we have the same kinds of concerns as a regulation that we would place out there on an operator or others. Is there a way that we can make broad language on this regulation that essentially asks the director to include all available reclamation reporting in the annual report without being prescriptive about it? And as that information improves, then we could include further things.
I think that is putting me a little bit on the spot there. I think it's possible. I would like the opportunity, which I think we might have here as we're trying to incorporate some additional edits to think about if that fits here. And if not, I don't know if Commissioner Ackerman, if you'd be open to SBP language around this. I'm just trying to think of different options here in case, we obviously don't want to craft something that's too broad, but I'm willing to work on it as best as possible with staff.
Yes, thank you. And I didn't mean to put you on the spot. I was just wondering conceptually if that's something we could consider, and would agree that I think that, I would prefer it in the regulation that was inclusive if possible. I think, again, you're a lot smarter than I am in the legal realm, and I think we're on pretty safe ground since it's a regulation that we are telling ourselves to do. But that said, I think we're all driving at the same point here, which is let's be as inclusive as we possibly can in the regulation. And if that includes some discussion in the basis and purpose that as we improve reclamation reporting data, we'll include that in the cumulative impacts report. I think that's helpful as well. So, Mr. Chair, I'm willing at that point to leave it in the capable hands of the AG and staff to kind of work on some language for inclusion next week. I'd be happy to chat about that offline as well if that's appropriate. And keep in mind that I sure would like to have the opportunity to meet with staff down the road to chat a little bit more about this. And certainly didn't mean to bypass opportunities for other commissioners there, Mr. Chair.
No, all that sounds good to me, all three of those issues. Anybody have a concern with what Commissioner Ackerman has suggested take place? All right, staff, you're so directed, and Commissioner Ackerman, you are so directed as well to work with staff and participate down the road.
Thank you all.
All right, Ms. Stafford.
Thank you, Chair Robbins. I think the next parking lot issue is another item from Commissioner Ackerman related to an addition to the cumulative impacts analysis related to surface disturbance.
Commissioner Ackerman, you're on a roll.
Sure, thank you so much. And again, this falls in a similar category here. And so I won't reiterate what I said, but this is another thing coming at staff very fast and includes a lot of processes and procedures that need to go under consideration as we're considering moving forward with this. I believe AAG Davenport forwarded some draft language to you in your inboxes earlier. I certainly can project that as well. But before we do that, I wanted to kind of, again, reframe this issue. And essentially what we're trying to do here is really start to get our arms around how we can improve surface disturbance mapping, particularly in the area of evaluation, and how we can use that data in a manner that helps us evaluate cumulative impacts on site as we're considering, as staff is considering, and as we're considering OGDPs and other developments, and how we can include that ultimately in our cumulative impacts calculations to really get our arms around surface disturbance and hopefully be able to incorporate some other layers into our GIS database that are reliable, that help us understand what surface disturbance looks like even outside of oil and gas development in a proposed area of development. And so as we were discussing this, one of the questions you might recall that I asked was, can we include a requirement for GIS submissions of operators on at least new operations that would help us start to get our arms around it in that way. And so what I proposed here in this language is the submission of GIS files, but also really tried to outline, and I adapted this from the wildlife hunting and angling groups. I also tried to get our arms around what an analysis of surface disturbance might look like within the area of impact. And so this proposed language talks about both of those things. Now, since that time, since this was just a couple of days ago, I've certainly had a chance to chat with Ms. Trask, who's had a chance to chat to some degree with some of our staff, and has, some trepidation as she certainly expressed during the hearing the day before yesterday. And so before it may not be necessary to go through this language, I wanted to ask Ms. Trask to talk a little bit more about her thoughts on this and what we can do and what we can't do. And do we need to go back to the idea of talking about a working group, or is there anything that we can include in the regulations right now that would start to help us get our arms around surface disturbance and actually incorporate it into the requirements for submission?
Thank you, Commissioner.
Ms. Trask?
Yeah, thank you, Chair. Thank you, Commissioner. Let me start with the GIS request. Some of my staff has had a chat with Chris Eisinger. He's our amazing IT manager, and his team runs our GIS platform and program. There is some concern about requiring GIS data, whether it's a shapefile or a geodatabase file. That is something that I would want to rely on Chris's team to determine what's the appropriate file type. There's some concern that since we are at some point in the near future moving off of our current GIS platform to a new Esri platform, that any data we might gather now, any GIS data that we might gather now, we might need to regather in a different file format once we translate over to the new Esri platform. And so my initial thoughts are that I'm a little hesitant to try to get GIS data, spatial data, through this process until we resolve some of our changing over to the new Esri JS platform. I might offer as a proxy that we could capture some of this information in just a PDF map rather than actual digital imagery. It could just be another map that is attached to the form that would show generally what those surface disturbance areas are. So that might sort of be a Band-Aid fix until we can revisit this later with the full support of our IT staff and GIS staff, and take the time to have a thorough, thoughtful, sort of programmatic approach to how we'd want to eventually gather the actual digital imagery data. So that's my first thought. As to sort of the rule language here, short of walking through it, some of this information would be hard for an operator to obtain. Pipelines and pipeline rights of way are outside an operator's ability to control, and that information is not always available. So I would be a little bit hesitant to require information that an operator would struggle to obtain and that we as staff would struggle to confirm or verify. So I think there might be some parts to this draft language that we could incorporate, but I think it would be mostly related to what the operator has available, information the operator has available to them, information that staff is able to vet. I think it's good information, but I'm not sure that adding it into this rulemaking is the appropriate time. I might recommend that this be another one of those SBP projects that then we can convene an internal or an internal-external working group to figure out what data actually do we want to review for surface disturbance, and how can we best start gathering that data in the right digital format.
Thank you.
Thanks. Go ahead, Commissioner Ackerman, please.
Sorry, Mr. Chair. Yeah, thank you, Ms. Trask, and masterful job of diplomacy there as well. Thank you so much for the way that you approach that. I do have a couple of questions there, and then maybe some suggestions. So, if we did require a PDF map, would that be able to ultimately be incorporated into an Esri system, or is that something that you might not know?
I don't know. My guess as a former geotech a million years ago is that it could be digitized, but that is not an efficient means of changing paper data into digital data.
Yeah, I would agree with that wholeheartedly from my background with GIS as well. And just a clarification that the language I proposed just talks about things owned and controlled by the operator up to and including pipelines. So wasn't asking for anything that they don't own or control. That said, my primary goal in moving forward on this front really is to start to acquire GIS data in a usable format that works for staff, that they can reasonably ask for from operators, and we can begin to really put together, as I've said a number of times during these hearings, an appropriate real-time updatable map of existing oil and gas disturbance and those types of disturbance. I think what Ms. Trask is diplomatically telling me is that it's a good idea. We can work on these things, that putting it in regulations right now might be difficult. So, Mr. Chair, on this one, I may be, I'm really chomping at the bit to get this into, as I find it would be really usable, not just for evaluation of OGDPs by staff and by the commission. Certainly, this is a key component to me of a cumulative impacts analysis on an annual basis and from an agency-wide basis. And so it's disappointing for me that we may not be able to get something like this in the regulations right now. You did mention earlier that you expect this to be an iterative process. I've asked that we put in our statement of basis and purpose opportunities for CPW and CDPHE to suggest to the director potential changes to us in the future. I think the director could also suggest those. I may just be reluctantly back to asking to work with staff on helping us plot a path forward here so that we don't, get out over my skis.
Everybody good with that suggestion? All right. Nodding of heads in the up and down fashion. Thank you, Commissioner Ackerman. Ms. Stafford?
Well, geez, Chair, just trying to make some notes there. I
No,
believe it's okay. I think the last thing on our list here is the discussion about the director's recommendation and potentially including some specific timelines in the rule. The way that I captured this, and I apologize if this was not totally correct, was discussion of a 30-day timeline with respect to 604B2 cap specific director's recommendations and the actual hearing date, and then a 14-day general timeline that I think both you and Commissioner Messner had a discussion about.
Yeah, that's right. And so, Ms. Trask, to reframe it, we've decided with the majority straw poll to keep the 604B2 site cap with site approval, preliminary site approval, as an off-ramp for 2,000 feet to RBU and DIC. I had suggested that I would like to see a period of time between director's recommendation issuance and then a hearing. Right now, I know that we generally shoot for, I think it's kind of like 2 weeks, but there have been times where director's recs come out the week before or a few days before. And so that would alter that point for the cap proposals. And then Commissioner Messner had suggested the idea of a just general 14-day between director's recommendation issuance and hearing for all OGDPs. And so we wanted to have a discussion with you about either and or both of those concepts and to get a sense of, impact on staff and doability, I guess, if that's a word.
Thank you, Chair. So I want to make sure that I took appropriate notes. A 30-day timeline from when the director's recommendation is issued to when the hearing takes place. And that would be for OGDPs or locations that have preliminary siting approval with their approved cap. And the operator is seeking approval under 604B2, that the cap off ramp.
Yeah. So operators, yeah. So yes, that's right.
Okay. Can I ask, and I feel like I should know this, and I apologize that I don't. Was this offered in any of the parties' previous presentations, and is there any red line language available? I'm wondering. Let me maybe just ask my question differently. I'm wondering why the 30 days? Why not 14 days for that?
That's a legitimate wonder, and maybe if we're thinking about this, it's just consistently, especially if we're thinking about expanding it to all OGDPs, having a 14-day time frame for everything. So maybe you can comment to that.
Sure. It has always been staff's intent to publish the director's recommendation 2 weeks prior to the hearing. Admittedly, and this I will take full responsibility in my role as the previous planning and permitting manager, staff always didn't always meet that 14-day turnaround. I acknowledge that leaves a very small window, maybe 3-4 days, for the commissioners and stakeholders to review the director's recommendation and prepare for the hearing. So let me just clarify, staff's intention has always been to have 2 weeks, have the director's recommendation published 2 weeks prior to the hearing. I do think that 2 weeks is reasonable, and I am fine putting that in the rule. I think this might be a question that could be directed to the planning and permitting manager, Ben Frizzell, since it's his team that works on those director's recommendations. So I can't speak for Ben, and I apologize. I wish I would have had time to give him a call before this and check in with him. I'm not sure if he's listening, and Ben, maybe if you are listening, you could get bumped up to.
I'm looking at the attendee list. I don't see Ben in the meeting at this point.
Okay, so not speaking for Ben, but speaking based on my own experience, I think 14 days is reasonable. Across the board, I think it's appropriate for 604B2, 604B4, and for OGDPs in general, because that is the goal that staff has been trying to meet, and so it wouldn't fundamentally change staff's process.
Well, it would, to the extent that it's mandatory from here on out. Like
it would. Yes, you're right.
For some reason the director's recommendation isn't ready, then it wouldn't qualify for that hearing that's 2 weeks out. And so I anticipate you might get some pressure from operators to make sure that director's recommendations go out. And I would like to explain to operators that if we go this route, we don't want that to happen. We want you guys to have the full and informed opportunity to ensure the director's recommendation is ready. And if that means it's not ready at a time that was promised, then that means it, getting it out ready and proper is better than just getting something out. Sorry.
No, I agree wholeheartedly. And what I wanted to say was that I would like an opportunity to provide some draft language that would describe how if for whatever reason there's new information or waiting for additional information from the operator or waiting for additional consultation with one of our sister agencies or waiting for a resolution from a public comment that came in late, then staff would have the ability to work with the hearings unit to change that hearing date so that all of those unresolved questions could then be resolved and then issue the director's recommendation. So I didn't want to imply that we would just have a date set and we would work to meet it. I'd like to have some language that would allow for staff or the operator to move the hearing date in order for staff to have time to resolve any outstanding issues in the permit application.
Commissioner Messner, this was one of the things that you had brought to the table as well. Do you want to provide perspective on this alternative that it's a 14 days for everything?
Well, to me, it was two different issues, right? And so I think that you had proposed the 30 days, which I agreed with, in particular circumstances. And I think that that's what we heard from stakeholders from a procedural justice standpoint. And I think that still makes sense. I think generally from a process standpoint, having 14 days, a director's recommendation 14 days before hearing is just good practice because it gives the commissioners enough time to be able to evaluate the director's recommendation and then be able to dive into the application with the director's recommendation in hand, which is really helpful because there is a kind of a halt in any changes to the application when the director's recommendation comes out that ensures that from a commissioner standpoint that I know nothing's going to shift in that application, and it gives me kind of a green light to really dive deep into certain aspects of the application rather than doing it too early when things are changing and then confusing myself. And so to me, that 14 days is important from a commissioner standpoint. I also think it's fair for the public and stakeholders who are also maybe following an application to have that procedural time to be able to evaluate an application as well and make a determination whether they want to continue to participate in the process and provide comment. And so I think the 14 days is good. The other 30 days I also think is good. And I would hate to lose that in this conversation because I thought it was a good idea that you brought up, Chair Robbins, and I would agree with that as well.
And I'm still comfortable with my initial thought for 30 days for the cap piece. And that just, means, Ms. Trask, that, the hearing on the cap piece it's not that your director's report is going to be slow in coming out. It's just that the hearing gets pushed out another 2 weeks. Okay. I also, none of this in my mind this is notice oriented, and it's not in my mind creating additional standing or petitions or anything like that. It's just to be procedural process. And so I would maybe, if that's an issue to our AAGs, would want to see some SBP language to sort of clarify what this is and what this is not, if that's fair. AAG Davenport, are you listening in?
Yes, Chair. I think it may be helpful to note that this 14 to 30-day notice would not extend a petition deadline if that petition deadline has passed in the SBP. That's not the intent, and we've had this discussion before, is that's also not intended to confer standing on anyone who didn't otherwise meet our standing requirement, Rule 507.
Yeah, so I think putting some clarifying language in the SBP would make sense here. So is everybody good with the 30 and the 14-day place that we've landed? Commissioner Cross?
Thank you, Mr. Chair. And I believe as long as this is specified as not being anything that's providing a different degree of notice, and it's just making sure that everyone sees the director's recommendation, has the information available. I am fine with that. I think that's beneficial to the public to prepare public comments. I think it's beneficial to the operators to be able to review anything the director may say in the recommendation. I think it's beneficial to us as well. With the clarifications that it's not doing anything to Rule 507, I think I'm fine with that.
Everybody else okay? Nodding of heads in the up and down fashion. All right. Other issues to come before us this afternoon? Commissioner Messner?
2 issues, I guess. One comment and then I did identify an issue at the beginning of the hearing today. I guess after taking a second, I want to, I guess, amplify Commissioner Ackerman's piece on the reclamation. And to me, how important this is, and how we have some experience with things going into the statement of basis and purpose from previous rulemakings that have taken years to happen, if ever. And so I wonder if that list that Commissioner Ackerman, the red line that he developed, could be re-reviewed, between now and Tuesday, and see if there are elements that we can get a head start on here in the rules to be able to start this process, acknowledging that there's other things that need to be worked on. And I understand the technology challenges. And I think in the rules, generally, we should be somewhat technology agnostic, but rather allow staff to work with operators to communicate with what technology needs to be utilized to be able to be compatible with whatever the system is today, whatever the system is 5 years from now and 20 years from now. But that would be my hope, because I really do think that this surface disturbance piece, particularly when the red lines that Commissioner Ackerman has provided, really talks about things that are under the operator's control and are known things, would be really, I think, helpful to our process here as we're tasked with evaluating and addressing cumulative impacts. This is a really big piece. And so that's a statement. And then the one that I had brought up earlier was, and I know Commissioner Ackerman will have thoughts about this as well. And again, I'm not trying to go backwards on anything, but I just wanted to have one more opportunity to maybe think about an area of evaluation associated with wildlife and adopting CPW's recommendation in an attempt to really have default areas of evaluation that should not have to be adjusted very often. And I think that's the intent of the default areas of evaluation, and trying to really get it right. And I do worry that in an attempt, as we had talked about earlier, and I think we had consensus on as a group, to really acknowledge that adjusting of that area of evaluation, the default area of evaluation, should be a relatively rare thing. And understanding that we've gotten feedback now from CDPHE that provided something different than a mile. We did get testimony from CPW that encouraged us to look at a mile around proposed oil and gas operations. I do worry a little bit that if CPW, is asked to provide thoughts on what an area of evaluation would be on an OGDP by OGDP basis, I wonder why they would not just suggest that a mile around proposed oil and gas operation wouldn't be what they recommended, because they've already told us that during this hearing. And so I bring that up just one more time, because my goal here is not to push any particular area of evaluation or say that anyone's wrong, but from a process standpoint, to minimize how much we're moving around the default areas of evaluation, because that does not create certainty to operators. And so that's my suggestion and thought, and I'm open to other commissioners' thoughts.
Commissioner Ackerman.
Thank you, Mr. Chair. And I very much appreciate Commissioner Messner. He's always been very thoughtful about wildlife and continues to be so. And I appreciate and admire his approach on a number of fronts, including this one. And so I appreciate you highlighting this, Commissioner Messner, and I do appreciate the Commission's thoughtful and discussions and consideration of the issue. And it might help to elaborate a little bit on why I landed where I did when we discussed this this issue initially. As part of the CPW discussion, you may recall that they mentioned actually a 1.25 mile buffer, since that's their largest buffer distance that they currently have. That's for lesser prairie chicken. which is a species restricted to the Southeast Plains in Colorado. And I at the time raised a question that extrapolating that, throughout as a minimum buffer might not be appropriate because of the limited nature of that species. And then there was discussion of a mile and around all operations, as Commissioner Messner talked about, which is it's a very valid proposal. And CPW did recognize that even that mile, even if it's around all of the operations of an operator, is really arbitrary for wildlife. The more distance you put between wildlife and development, the better. Some species don't need a mile. Some species need quite a bit more than a mile. And CPW then, stated that if the commission did adopt a mile from the PAD standard, it would be important to include language for CPW to be able to consult and suggest changes to the area of evaluation. And so the current draft then resulted in 315B2A sub 2. And it states, in determining whether it is necessary and reasonable to expand the areas of evaluation, the operator will defer to input from the director, the relevant local government, CDPHE, and CPW, which provides a pretty strong opportunity for CPW to suggest changes from any standard, whatever standard we issue as the base standard. And one of the issues that resonated with me is that CPW, it kind of alluded to this, but having the background that I do, I know what they meant, and that's that they consult pretty heavily with us on HPH. When there's HPH out there, it's a trigger. They know that it's triggered, and then they consult. Consulting with us on every single application to that same degree really is impossible for their structure as currently constituted, although they do often participate at some level in any of these meetings, these initial meetings, to kind of get their arms around, what's going on. And what I was trying to do is to keep the areas of impact or evaluation as default as possible for simplicity's sake, while really encompassing, in most cases, those peripheral operations anyway, with the opportunity for CPW to expand when they go outside of those of that default distance, whatever it may be. And to be fair, subsequent to that, as Commissioner Messner just brought up, we did land on a separate AOE for water, which does sway me a little bit if we're going to start talking about separate areas of evaluation for different media out there. It would make sense for wildlife, one of our most sensitive subjects, to have some consideration on that front as well. It's of note, though, that the water AOE really is simply just a larger circle. The 1 mile radius is from the pad is a pretty easy to not evaluate, but an easy to understand and map circle of impact to consider impacts. So would a larger circle be 2.5 with the obvious with the 5 mile downstream caveat that we included there. And my way of thinking was that for wildlife, if we extend the buffer to all peripheral operations, essentially what that does is it creates a number of unique and abnormal polygons in every evaluation, for roads particularly, and for other disturbances, which significantly increases complexity. Now, I'm all right with increasing complexity if it's necessary and if we get the benefit from increasing that complexity that we need in order to properly evaluate impacts to wildlife. So really, to further explore what that complexity would look like, we'd have to examine case by case what types of roads are included. Are we just talking about roads that are specific access roads to the pads? Are we talking about all roads used for any oil and gas activity? Like county roads, some of which are paved and heavily trafficked with minimal additional impact to wildlife, and some are dirt and cut through relatively high quality wildlife habitat with little traffic that do impact wildlife that may be outside of that radius. And so in my opinion, these are some of the judgment calls that, in my mind, the way I worked it out, that need expert agency input. And that was hence my leaning toward really an easily understandable and usable base area of impact, or area of evaluation, we're calling it. And then making it very clear that agency discretion is important. And that leads us to the discussion we were having earlier today, to the point of modifying the base AOE. We discussed the concept from the perspective of the commission, that we thought that that discretion should be used very rarely. And I agree with that, since the commission review really is at the end of a very complex process. But at the time we discussed this issue initially, to me, in my, as I recall, and from my perspective, my opinion was that there should be pretty free available use of discretion to modify that area of evaluation by those agencies. I think I've either conflated or we've maybe convoluted the water a little bit, because I think we've said a number of times now that on that aspect, our intent would be for that judgment to be used quite infrequently as well. And I'll have to say that if that's the case, it certainly changes my perspective on this issue. So if we go forward with the regulations as written in the 1 mile standard, I definitely do not agree with the point, and believe that and expect CPW to identify all of those areas in which the operations are not encompassed within a default AOE, and evaluate whether or not, in their professional judgment, those operations outside of that area of evaluation add to cumulative impacts to wildlife and should be addressed. And so we heard testimony from wildlife folks that the area of evaluation for wildlife expands, many cases, farther from 1 mile radius from the well pad. I agree. That's absolutely the case. And CPW's testimony was that in some cases, the area of impact might be 10 miles, where there are long access roads and pipelines. In other cases, it may only be a few hundred meters, because the location is adjacent to or within an existing footprint of disturbance. And another aspect of my thinking was that there certainly are developments in Northwest Colorado particularly, and probably some of the helium developments down in Los Animas County, in which roads will extend outside of that mile area of evaluation that we've talked about as a default. Again, once again, depending on whether we include only existing ranch roads or, of new roads specifically for pad access. And then conversely, in the DJ Basin, where the preponderance of oil and gas activity takes place, in my opinion, it's unlikely that there will often be a need for expansion of the area of impact, or of evaluation, excuse me, in order to incorporate roads and other peripheral operations, as most of the time they do fall, from my at least short experience, within that 1 mile boundary from the well pad. So once again, unless the broad understanding of roads is all roads used in any way by oil and gas traffic, in which case an argument could be made that we should trace those impacts all the way to, for example, a produced water disposal site. So in my opinion, I think what we're talking, and I know, this has raised some consternation among wildlife groups, but I do think we're talking about two ways of getting to the same place. And so, as I tried to state earlier, not very eloquently, it is technically more accurate to include all those disturbances to wildlife in the base AOE. Again, the mile is not accurate, even if we expand it to all operations, but it's more expansive if we expand it to all operations. And I certainly am in favor of protecting wildlife. And I'm certainly not arguing that impacts don't exist outside that radius. So if we're looking to minimize agency use of the expansion of the area of evaluation, where it's prudent in our sister agencies' opinions, it would be appropriate, from my opinion, and accurate to expand the base area of evaluation from just a mile from the pad surface to a mile around all operations as requested by CPW. That also includes an opportunity for them maybe to not have to consult as intensely on each operation. That said, to me, if the commission's in favor of a more default approach with, I guess, more complex evaluation polygons thrown into a mix with less frequent suggestions for modifications by agencies based on site-specific conditions, it makes sense to go in that direction. It's arguably more protective of wildlife from a base level. It's less reliant on CPW's engagement and judgment. I wasn't working under the impression at the time that it would be rare that area of evaluation would be suggested for modification by CPW. And I can see why Commissioner Messner is raising this point. if we want to be more, if we want to create a situation in which the preponderance of cumulative impact is going to be addressed by setting a base distance area of evaluation from the well pad and making it clear that CPW can and should include anything else that is of concern in that area of evaluation. Remember, we're just talking about further evaluation here. That creates an easier system for our constituents to work with. And thinking of it from beyond a wildlife perspective, my thinking was that this gathers the preponderance of the impact with opportunities to gather any additional impact available to CPW, again, at more labor to them. And that led me to landing at that point. So to sum up that diatribe, essentially what I'm saying is that if we are in favor as a commission of setting what we think is the most accurate area of evaluation from a base level and minimizing potential changes from that area of evaluation, I am in favor of expanding that radius to all operations. If we as a commission are okay with CPW being able to evaluate from the base level of a mile from a well pad, and if deference is given to them, such as we state in the regulation, to expand that area of evaluation at their discretion, then I think that that's an appropriate approach. And happy to discuss any further, Mr. Chair.
Initial thoughts, responses to the summary as provided by Commissioner Ackerman with the two approaches proposed. Commissioner Messner.
That was great, Commissioner Ackerman. I really appreciate that. And if that could all be captured in the statement of basis and purpose, I think we'd be fine. But it does highlight perhaps even where I'm conflating things right now. And so to be honest with you, I agree with both of your points. So whichever way we land, I'm comfortable with that, the two options that you created, because I think it ultimately is protective and gets to the point that I'm trying to make. I guess I was understanding from Chair Robbins' suggestions on the kind of clearly it's erroneous standard that the intent on that conversation was to try to not adjust the default areas of impact. And that's why I suggested maybe we relook at the wildlife piece. But if it is true that this commission intends to allow CPW to create a wildlife specific, depending on what wildlife is there, area of evaluation on OGDPs, and then that carry through the process to us, then I actually, and deference is given to CPW on that. And then I guess I'm agreeing with your second suggestion. If we truly are looking to not want to see much adjustment at the operator or staff level of the area of default, then I would agree with your first suggestion, which is to get a more accurate area of evaluation. And so I guess I'm curious how other commissioners interpreted that.
Well, and just to, since you called me out on what I was suggesting that the commission at the end of the day and at the hearing ought not be adjusting what the director and the agencies have come to relevant to the defined area of evaluation. I'm perfectly comfortable with the concept that in regards to wildlife, we start with the mile and CPW is given deference to, on a case-by-case basis, determine that it ought to be greater and depending upon the circumstances. And that doesn't conflict with the point I was making about the commission making changes. So having said that, I also could go either way on this front. And ultimately, I'd probably go whichever way Commissioner Ackerman decides is the best. Commissioner Oath?
Thanks, Mr. Chair. I tend to agree with that leaning of sticking, at least for now, with the 1 mile default for wildlife with certainly latitude for CPW to weigh in on suggestions for expanding that and require, the provision indicating that an operator should be deferring to that. What I think I understood, and from what Commissioner Ackerman's summary was, and my recollection of CPW's testimony is that it's quite hard to pick a default value for wildlife that's going to be appropriate kind of statewide. And this might be one that varies case by case, and would be comfortable with that. So I guess to me, what I meant, or as we've talked about, not expecting to vary from it frequently, was not a caution to either CPW, CDPHE, or the director or local governments to not go beyond that very often, but more that we think that in general it's the right one, but that we want to keep an eye on that. And if we find that it's being adjusted over time frequently, that might lead us towards shifting the default. And this might be an area in particular that we want to keep our eyes on. If, CPW is frequently suggesting a different, area of evaluation and it seems consistent, then that might lead us to wanting to adjust it based on kind of our experience over time and CPW's experience over time of what seems to be kind of more appropriate in most cases. So those are my thoughts.
Commissioner Cross?
Thank you, Mr. Chair, and thank you to my fellow commissioners for taking the lead on this. First off, I think it was very well detailed by Commissioner Ackerman. I personally think that leaving the deference to our sister agencies, whether it's the default 1 mile for CDPHE to look at or the default 1 mile for CPW to look at, is an appropriate way to go. I think as Commissioner Ackerman noted, it's not always going to be a lesser prairie chicken and some of the wider things there. It might be a much smaller impact area. And so I think it's easier to start at something that we kind of have set as a default. Is this appropriate? And as they're talking pre-application, understanding, is this appropriate, should be looking wider. I think in the same way we've talked about the director being able to say, yeah, but just past a mile here, there's also a school. Do we want to include that school as part of it? I think that that's something that is best left to the experts, whether it be CPW, CDPHE, our staff, the local governments, as they talk about these issues before the application is put forward and understanding, again, I know Commissioner Messner doesn't want to say a decision is not made at the pre-application meeting, and I completely understand that. But the hope is that there's at least some sort of consensus, some sort of understanding that whatever these experts decide is the appropriate area of evaluation should be the area of evaluation selected by the operator. And if it's not, and they choose to go with something else, they're going to probably face a pretty big uphill battle the rest of the way coming before us. So I think it is best to put that deference to our experts, whether it be CPW or CDPHE or our staff, to say, yes, this is the 1 mile should be expanded upon. And so I think it's a lot easier to start at that kind of understanding of the 1 mile here that can be expanded on. And as you said before, Mr. Chair, I think the hope is that by the time it comes to us, as you stated, as we look at the record as a whole, there should be very few, if any, times that we should have to change the ultimate decisions made on the area of evaluation when it comes to that. But I do think that that's separate than what we're trying to do in determining what the default should be here. So I think it's appropriate to stick with the 1 mile and leave that deference to the expert agencies, local governments, and staff to say it should be something different.
And Commissioner Cross, and this is an open question to all four of you. When you say full deference, I mean, ultimately the operator makes its determination of the area of influence. And if we go with the 1 mile and CPW is kind of the base, and then there's a check-in with CPW, and they, in an instance, suggest because of, animal X, we think it ought to be why this time, the operator takes that into consideration. And if they decide not to go with that, that's at their risk. I mean, I'm trying to figure out like how the deference sort of, I mean, like deference doesn't mean that it, becomes whatever that new thing is for that one instance. That just goes into the equation for the operator who carries the burden of proof. Do I have that right? Is that how you and Commissioner Ackerman are thinking?
And I don't want to speak for Commissioner Ackerman, but I think that's accurate. And especially, I think even, and again, I don't want to speak for the experts, but I would guess that just based off of the quality of habitat, which we hear about sometimes from CPW as well, there very, very well may be a point in time where they say, this is high quality elk habitat, and we really don't want to have any fragmentation in this. This is something that we really need to look at. So if that's just over the mile, like, yeah, let's look at 1.5 miles and make sure that we're taking that into account. But there may be other areas where they say, I know we looked at 1.5 miles for the elk before, but this is an area where there's already quite a bit of fragmentation. Maybe we don't need to do that 1.5 miles here because of the existing impacts to it. And I'd much rather put that decision in the hands of the experts. And yes, when it comes to difference, I think it's a case-by-case basis for one, but ultimately and this is part of what we talked about in the 301 discussion as well. As we start to talk about what happened in the pre-application meetings, and understanding, here's what was talked about with the area of evaluation, here's what was talked about with BMPs, about site location, et cetera, get an understanding that if we find out CPW since day one has been saying this area of evaluation should have been 2 miles, not 1 mile, because this is really important habitat, and the operator says, yeah, but we're going to stick with 1 mile, I think that's where they're going to really face that uphill battle moving forward. And so that's why I say the deference given to the expertise of the agencies or the local government or the staff as the case may be.
Commissioner Ackerman?
Thanks, Mr. Chair, and thank you, Commissioner Cross. And we're on similar pages here. And I would just add that for me, the burden here of deference, of proof for deference is very, very low, since all we're asking for in this case is further evaluation. There's no restrictive action or other thing that the operator is being asked to do. So I just want to make clear that for me, what deference means is that if in our staff's professional judgment or in CPW's professional judgment or the relevant local government or CDPHE's professional judgment, that's enough of a burden of proof. Their recommendation based on their professional judgment and based on their history of consultation with our agency and with operators is enough. And this regulation currently reads, the operator will defer to input from those entities. And I would second Commissioner Cross's point in saying that if one of those entities has clearly recommended a difference in area of evaluation and the operator has chosen to ignore that, I wouldn't consider that regulation to be compliant with.
Commissioner Messner?
Thanks for the discussion. This has been great. It gives me more comfort and also helped me understood how we were going to apply this versus how we were going to apply the other thing we talked about earlier. And so I'm on board with this. I agree with it. I think it makes sense. I like the deference. I want our sister agencies and staff and relevant local governments to also, I want them to feel comfortable making recommendations then that are different than the default area, that they feel like they have the authority to and the confidence to. And so I would, this is a statement of basis and purpose piece, but I can't say it any better than Commissioner Ackerman already did. And so as the statement of basis and purpose is getting developed, I think really focusing on the rationale and the way that Commissioner Ackerman presented it just now, I think is important to capture in the statement of basis and purpose, because this is one of those rules, in my opinion, that has the potential to be misinterpreted. And so I think making sure we capture this in the statement of basis and purposes is critical. So thank you, Commissioner Ackerman. Thank you, Commissioner Cross, for your thoughts on that, Commissioner Oath. So.
Commissioner Ackerman.
Thank you. And again, thank you for raising the issue, Commissioner Messner. And I meant to state in the deference discussion and wanted to kind of complete this discussion by saying that this is something that I believe we can continue to evaluate. And this is one of the reasons that it bodes well to talk with CPW in order to suggest adjustments as a result of our annual cumulative impacts report. If this just isn't working, and if they're getting a lot of pushback, and if there are concerns that they raise, I certainly can see myself proposing that we reevaluate how we approach this issue.
AAG Stafford. That was a lot of talking. Did you get all that summarized down into a paragraph or so for the SBP and the actual rule?
Thank you, Chair. I will manage, and if we have to, I can go back and review the hearing as well.
Or you can call up Commissioner Ackerman. It's all his fault.
Okay.
All right. I think we've reached consensus on that point. Are there other items in our parking lot or otherwise before the commission this afternoon? Seeing nothing from Ms. Stafford, do commissioners have anything further on any issue? Commissioner Messner, you're unmuted.
I've got one, well, just a clarification. I guess you had suggested, Chair Robbins, I think I've suggested, I think a number of commissioners have suggested, that while there's some elements of the mitigation hierarchy that now are going to be incorporated in the rules, but there has to be, some significant discussion in the statement of basis and purpose associated with the mitigation hierarchy. And so my question is, I guess, is to AAG staff, or do you need anything else from us to help kind of build out that statement of basis and purpose language? Is there anything that would be helpful, or are you comfortable with it and we'll just see what comes out on Tuesday?
I am always open to input. I think we have good notes, and I'm also able to go back and review the hearing if there's some issue I need some additional clarity on. But I don't want to stop you from providing me with input if you choose to do so.
I'm not saying I have any additional input. I'm just asking if you need any additional input from us, and if not, then I'm comfortable keeping my mouth shut.
Is that a question for me? Sorry. I think I'm good to go. Thank you.
All right. So with that, I think we've made our way from beginning to end through the rules. We've provided direction on all the rules. I believe at this point, we're going to be done with the hearing for today and reconvene on Tuesday the 15th at 9 a.m. I believe it's probably appropriate to now close the record, but I would ask AAG Davenport to visualize and help us with that discussion.
Thank you, Chair. My advice on closing the record hasn't changed, and I note that the commission can always reopen it on Tuesday. But if the commission does not intend to hear from the parties, then closing the record would be an indication of that.
Generally, we've rejected your recommendation on that front the last two times. I, in this instance, would be comfortable with closing the record, but I'm one of 4 votes and I'm usually outvoted. So the other commissioners, what's your pleasure? Commissioner Messner?
I just, my only concern, I don't have a problem with closing the record. I mean, I think we got, but we've asked staff, and perhaps even Commissioner Ackerman to engage with staff, you know, between now and Tuesday. And I don't remember if that's true or not, Commissioner Ackerman, so I don't mean to put you on the spot, but, does that preclude us, AAG Davenport, with interacting with staff between now and Tuesday?
Well, I think that may depend on what type of actions you're potentially looking for. If it's simply clarifying intent or staff checking in to make sure they've adequately captured your intent, then no, I don't believe so. If there's going to be discussions with staff between individual commissioners about changing the substance of the rules and BP outside of what you've already discussed today, then I would recommend not closing the record. There's no way to sort of close the record for one group of people, but not others. It's a binary call.
Yeah, and I think the only interactions between commissioners and staff would be to clarify. I don't believe we have contemplated that individual commissioners would have the ability to alter places that we've landed on things. At least that's my perspective. And so if that's the case, then what I'm hearing from you, AAG Davenport, that would not be a problem if the record is closed. Does any commissioner think of it otherwise? Okay. Are we comfortable then closing the record? Do I just say the record's closed and it's closed, or do we need to have a motion?
A motion would be preferable.
I move to close the record.
Second.
Motion and a second to close the record. Further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? The record is closed. And so next steps are, once again, we've lofted a heavy lift to staff. We appreciate you more than you know one more time, and we look forward to getting back together with you on Tuesday morning for what I believe could be the final hearing on the cumulative impacts and enhanced systems and practices docket. So with that, Ms. Trask has her hand raised.
Thank you, Chair. Might I ask for direction on when and how staff might issue sort of this final draft? Should we plan to issue the draft publicly 9 a.m. Tuesday?
I mean, I'm comfortable if you get done with it before then. At least this is just one commissioner releasing it to everybody so that everybody can read it ahead of time, and we're not reading on the fly on Tuesday morning. AAG Davenport, do you have thoughts about that?
Well, I think it's your preference on what you'd like to do. I think we recognize that certainly having a little time to read it in advance would be preferable, at least for the commission.
I mean, again, if you guys get to a place where you're comfortable, you think you've met the intent of the commission, I'm comfortable with you going ahead and releasing it to commissioners as well as our stakeholders, with the caveat, and you might put this across the top, that this is staff's work, and the commission, will have the right and the requirement to confirm that the version is consistent with the direction that we provided, or some disclaimer like that. Does that work for staff and AG Stafford?
We'll work as hard as we can to get it published as quickly as possible. I might, just given our past experience, I might say we could aim for noon on Monday or something like that.
That's what I was going to say too. Aim for noon on Monday, but just if you're not ready noon Monday, then, and if it's Tuesday morning, it's Tuesday morning, and we'll just deal with it. And if it's Tuesday morning, what we may do is we may convene, grab our drafts, and then take an hour or two break to give everybody a chance to read it. and there's nothing wrong with that. So we'll cross bridges as we get to them. All right. Anything else for the good of the cause, Commission? Seeing none, this matter is continued until Tuesday, October 15th at 9 a.m. Thanks, everybody.